Hello everyone, a very good evening to all of you. Welcome to the JAIIB CAIIB English Medium channel by Adda 24/7. So let's start the final revision for your BRBL exam, and I hope so your all concepts are very clear. So let's do the final revision for BRBL and all the best. Okay, now the first question on the screen, as you can see here, that state which of the following statement is the true statement? Okay, the first is the public sector bank is a body corporate that is created under the special statute. Okay, banking company is registered under the Banking Regulation Act. Cooperative banks are registered under the Multi-State Cooperative Society Act or State Cooperative Society Act. So this is your statement based question. Okay, so see, in this type of question now, just click on one question, one statement. If you know the one statement, you can easily solve the question. Okay, so here the first is the public sector bank is the body corporate created under the special statute. This is the right statement. Why this is right statement? Because we know that suppose if SBI is there, so SBI comes under the SBI Act 1955. So this act that is made by the parliament. So that's why it is a special statute. Banking company. So first is right, first is right, first is right, A is right. So answer will be from first, second and third. Banking company is registered under the Banking Regulation Act. This is the wrong statement. B is a wrong statement. B is a wrong statement. Why? Because every company have to be registered by the Companies Act 2013. Okay. So second statement is the wrong statement. Done. Cooperative bank are registered under the Multi-State Cooperative Society Act and the state. So this is the right statement. So A and C is the right statement. So that's why this second is the right statement, right answer. So always try to solve this type of question in that way. Okay, so just pick any one statement, and if you know the statement, you can easily solve this question. Okay, done. Now next one. Yeah, the next question. Which of the following statement is the false statement? Okay, so we have to identify the false one. Central government can give directions to the Reserve Bank. Okay, all kind of business of bank are regulated only by the Reserve Bank. Central government is the primary regulator of all bank and state government have no control over cooperative bank. Yes, plus tell me. Which of the following statement is the false statement? Okay, the first statement. Central government can give direction to the Reserve Bank. This is absolutely right statement because we know that if we have a central government, so central government RBI is there and then we have a other banks. So all banks have to work under the guidance of RBI, and this RBI, they have to work under the central government. So that's why central government can give direction to the Reserve Bank. Okay, so first statement is right, first is right. It means this cannot be the answer. Right now, all kind of business of bank is regulated only by Reserve Bank, only. Okay, state government is the primary regulator of banks. C is absolutely wrong. C is absolutely wrong. C is the wrong statement. C is the wrong statement. Why C is wrong statement? Because the Reserve Bank of India is the primary regulator of all the bank. Is that okay? State government have no control over this. This is the wrong statement. So B is wrong. C, D is wrong and B is, this is not the only by Reserve Bank, no, because we have a Banking Regulation Act. Okay, so under Banking Regulation Act, the bank have to follow the rules and regulations. So B statement is also wrong. So B, C, D. So that's why this is the 4 is the right answer for this question. C class. So this type of question, always try to understand. Okay, always try to understand the one statement, and when you understand one statement now, I think you can easily give the right answer. Is that okay? And if you have a doubt, you can please ask in a comment box. Okay, so that is done. Now, next one. Next statement. Dash may apply to the High Court for winding up of a banking company under Section 38 of the Banking Regulation Act. So guys, we know that in Module A, only two acts we have to study, that is Reserve Bank of India Act and the Banking Regulation Act 1949. Okay. So in this question, in this statement, one question is also there, that from where we can apply the winding up. So we can apply the winding up in the High Court. So this can be also come in the form of question, okay? And dash may apply to High Court for winding up the banking company under Section 30. So in this statement, the three questions are there, right? The first question, winding up of banking company, okay? So this is High Court. One question. Then what is Section 38? Okay. And who can apply? That's the question that is asked. Who can apply for the wind up? So three questions are made in this statement. Okay. So the right answer will be Reserve Bank of India is the right answer. Okay. So guys, see, if it is possible, you can also see the question answer session in the bilingual class also. Just see the questions. These questions are different, and the questions that I'm taking in the bilingual class, that is different. So you can just see all the sessions because all questions are important. Okay. I just used to take class in the bilingual language also. So that's why in both medium, my marathon is going on. Okay. Done? Now, next one. Okay, which of the following statement is the false statement? Now we have to identify the false statement. Okay, the maximum period of office that may be held continuously by ordinary director in a banking company is 8 years. That's a tenure that is given here. Okay, the decision of board of director during the period when board constitution is defective shall be void. The post of chairman of banking company may be the part-time basis, and the chairman of banking company can hold office for the maximum 8 years. So just pick one statement and then give me the right answer. Yes, class. What is the right answer for this question? This is very important question. Very important question. Let's do the same trick that I have told you. In this type of question, just try to solve the statement which you think that is right. 100% accuracy should be there. The maximum period of office, okay, that is held continuously by the ordinary director is 8 years. First statement is right. First statement is right. And we have to tick mark on the false statement. Okay. First is right statement, but for chairman it is wrong statement. D is wrong. D is wrong. So guys, the answer should be from third and fourth. Why? Because you can see here in D point, the chairman of banking company can hold office only the maximum period of 8 years. The D. Cool. Then the post of chairman of banking company can be maybe the part-time basis. This is the right statement. This is the right statement, guys. C is right. Now B, the decision of board of director during the period when board's constitution is defective shall be void. This is the wrong statement. This is the wrong statement. So that's why this 4 will be the right answer. So these types of questions are one of the easiest questions. So that's why please focus on the concept. Law is nothing but common sense and logic. So please apply your common sense and logic. That's it. Okay. So I hope so. This is clear to all of you. Do not ignore module A. We know that mostly question asked from C and D, but always focus on B and A also. Okay. Now, next one. Okay. A company, right? A company through the advertisement offer to pay 10,000 to anyone who get flu after drinking their cough mixture. So it means a company is there, right? The company ad, it's a advertisement in the newspaper that the company will give the 10,000 to anyone who will drink the cough mixture, okay? And if he got the cough, the company will pay 10,000. A person who took the cough mixture, contact flu and flight action to recover 10,000 from the pharmaceutical company. Now tell me class, in this case, whether the company is liable or not, because suppose if X person have taken the cough syrup and suppose the flu is, not, we can say, after drinking the cough syrup, X still suffering from flu, but the company is saying no, we will not give you this compensation. So tell me whether this company, okay, whether this company have to pay 10,000 to X person or not. So four options are there. The first option, company is not liable to pay as offer was not made to anyone personally. It was journal offer that needed no communication of acceptance, therefore company was liable. The person should have communicated his acceptance to the company, or none of the above. Tell me class, the right answer. This is very good question. Okay, this is very good question, and it's a famous question because the case that is come, the case studies that is come from the case is pharmaceutical company. Just try to remember the one word. It's a pharmaceutical company case. So this question, the company is not liable, this is a wrong statement. Why? Because see, if the company have ad in the newspaper, so in that case the company is absolutely, we can say, liable. Okay. It was journal offer that needed no communication of acceptance, therefore company is liable. Person should have communicated acceptance. See, what is journal offer? Because see, in this statement we have a journal offer. So what is journal offer? Journal offer is simply, suppose there's a two offer. The first is specific offer and the second is journal. Specific means, suppose if Nikkita ma'am is selling my car to Neha ma'am. So Neha ma'am, you are the specific one. Nikkita ma'am is offerer, you are offering. That is a specific one. And what is journal offer? So journal offer is basically that is offering to everyone. Offering to everyone, this is called journal offer. So that's why guys, this B is the right answer. And this is the landmark case that I'm telling you. It's a landmark case, okay? So B will be the right answer. Cool. So journal offer, special offer, please understand this concept. In journal offer, suppose this company have advertised, that's a journal offer. If one lady have accepted, it means acceptance. Acceptance is there. And guys, we know the formula. What is the formula? Let me tell you the formula of this one, offer. Okay. So we have offer plus acceptance. Offer plus acceptance is equal to promise. Promise plus consideration is equal to agreement. In agreement, when law will enforce, this is equal to call contract. So this is simply the definition of contract, and you people have to understand. This is very, very much important formula of a contract. So because we know that the Indian Contract Act is divided into the two parts, that is general principle of contract and the special principle of contract. So when general principle of contract, this formula applies. So that's why this is the right answer. Okay, so now let's do the next one. Where the right of lien can be exercised. Right of lien. If I say right of lien, right? So lien is what? Lien is of two types. That is specific lien and general lien. So what is the basic difference between specific and general? So lien is basically to hold. What is lien? It is basically to hold. Specific lien, suppose if Nikkita ma'am give Taylor a cloth for stitching the suit. In that case, if Nikkita ma'am is not giving the price of the suit, tailor have a right to just take my suit. This is called specific lien. So tailor will apply his right on my cloth, suit. And what is general lien? The banker lien is the best example. Banker lien is the best example because see, general lien is given in section 171 of the Indian Contract Act. So banker lien, attorney client. So these are the examples of general lien. Suppose if borrower is not able to pay the money, so the bank have a right to hold all the documents of the customer till the full payment is not done. So this is your general lien. So right of lien is exercised where some documents valuables are left in the bank possession by customer by mistake, where security is given to bank to secure a loan but that has not been granted, where there is any contract inconsistent with the right of this. So inconsistent, this cannot be the right answer. Where securities are given to bank to secure a loan but that has not been granted, no. Where some documents valuables are left in the bank possession by customer by mistake, no. No, none of the statement is the right statement, so that's why D will be the right answer. So right of lien can be exercised when borrower is not able to pay the money. That's it. So this is the right answer. So for sixth one, D is the right answer. Okay, now next one. Pledge. Pledge, which is defined in section 172 of Indian Contract, means what? See, Indian Contract Act, okay, that is general principle of contract and special principle of contract. In special principle of contract, section 124, section 126, section 148, section 172, section 182. So 124 is what? 124, contract of indemnity, contract of guarantee, contract of bailment, contract of pledge, and this is contract of agency. So 5 terms that is written here. Okay, and in general principle of contract, the formula you have to learn, that is offer, acceptance is equal to promise, promise plus consideration is equal to agreement. In agreement, when law will enforce, that is equal to contract. So that is the basic crux of the Indian contract. So pledge is a bailment of good. This is the right statement. It is a bailment of good to grantee a loan. Bailment of goods as security for payment of debt and performance of promise. So if you see the exact definition, because as I already told you, that definition portion will definitely come in your exam, definitely. So in 172, this C point is the exact wording of your Indian Contract Act of the pledge. So that's why C is the right answer. So what is pledge? Pledge means if Nikkita ma'am is taking loan from the bank and she is giving movable property as a security, that is called pledge. Okay, so in pledge, that's deal with the movable property, right? So many students confuse with the hypothecation, that pledge and hypothecation. So I'm just telling you a small brief intro of this. If I just say pledge, so pledge, I'm taking loan. In hypothecation also, I'm taking loan. Pledge deal with movable, hypothecation also deal with movable. Okay, in pledge, the borrower is giving security. The borrower is giving the possession of the security. But in hypothecation, the possession and the ownership of the good is with borrower. That's a basic difference between pledge and hypothecation. So pledge, possession is with creditor, and in hypothecation, the possession ownership is with the borrower. So that's the basic difference between pledge and hypothecation. And I hope so that is clear to all of you. If you have a doubt, you can please ask in a comment box, okay? So right now you are seeing this session. If you have any doubt, you can please ask in the comment box, okay? So I hope so that is clear to all of you, okay? Next. Okay. The customer, okay? A customer opened a saving bank account with the introduction of employee of a bank. Customer open an account with the introduction of employee of a bank. This employee was the neighbor of customer and therefore entrusted with amount 12,205 to be deposited in the saving bank account of the customer. Employee made credit entry of 12,205 in the saving bank passbook of customer but embezzled the amount. That's a wrong thing that is done in this case. The customer filed the conversion against bank. Tell me, bank is liable, bank was not liable. The bank was responsible, bank must take action. This is very important question and very good question, guys. Very important and very good question. Tell me, class. Very good question. So, class, see this question. That is important. Always remember, we know the concept, that is agency. What is contract of agency? The relationship between customer and the bank is, we can say, the agent and the principal is called contract of agency. Okay, in this case, the customer opened the account with the introduction of an employee of a bank. This employee was the neighbor, okay, neighbor of the customer, and therefore entrusted this. So neighbor. So see, if agent is doing work under the course of employment, it means, suppose if agent duty is only 7 to 7 p.m. in that case, now 7 to 7 p.m. in that case, the principal will be liable. But in this case, the customer have given the check as a, we can say, the in the form of neighbor. So it means that's not come under the course of employment. So that's why the bank is not liable. So bank is liable? No. Bank was not responsible? No. The bank was not responsible as loss was not committed by employee in the course of employment with the bank. So guys, this B is the exact answer for this question, B. Okay, because as we know that, what is course of employment? So if you see course of employment, so course of employment is basically, if I say, that means during the working hour. What is course of employment? During the working hour, that's it. Okay, so this is the right answer. Is that okay, class? So I hope so. That is clear to all of you. B is the right answer. Done? Now, next. Under section 26 of the Banking Regulation Act. What is 26? It's talk about the unclaimed deposit. What is unclaimed deposit? Suppose if any deposit after 10 years, if it is not claimed by anyone, that will be called as the unclaimed deposit. So under section 26 of Banking Regulation Act, okay, the banks submit to RBI the return on dash basis within dash from close of the said year relating to dash. So as we know that 26 is unclaimed deposit, so this answer can be from B and C. Tell me, class. So this is always done in the yearly basis. So B will be the right answer. Okay. So section 26, let's talk about the unclaimed deposit. This is the right answer. Okay. This is the right answer. Done, guys? Next. This is very, 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 very much important. So first of all, see, this is again a statement based question. Try to catch the concept. If you know the concept, you can easily do that question. Okay, now see here. Lalu is going to Ayodhya for a pilgrimage. he left his cow Dudheru, it's the name of cow, with his neighbor Meera. So Meera is one person, Lalu is one person. In consideration that she could sell the milk as long as she had the cow. After he left the price, the milk shot up due to the heavy seasonal demand. Meantime, the cow got pregnant through the Hira bull. The cow delivered a healthy calf named Kandheru by Meera. When Lalu returned, he asked back for the cow, the calf and the part of profit due to increase the price of the milk. So tell me class, in that case, what things Lalu can take back? So we have a 6 point, right? That Lalu is not entitled for profit of the milk. Lalu is entitled for profit of milk. Lalu is not entitled for cow, entitled for cow, not entitled for calf, entitled for calf. So 6 statements. So first of all, tell me the exact reason and then exact concept. Tell me the concept and then give the answer. Yes, class. Very good question. It's a very good question. So class, this is very simple and the easy one. First of all, Lalu is entitled for cow. 4 is the right answer. 4 is the right answer. 4 is the right answer. So guys, answer can be from C and D because 4 is right. Lalu is entitled for calf. Yes, 6 is right. 6 is right. 4 and 6 is right. I think first is absolutely right. Lalu is not entitled for the profit of the milk. So C is the right answer. Why Lalu is not entitled for the profit of the milk? Because Lalu already say to Meera that you can use the milk of the cow. It's her luck that when Lalu go, the price of the milk just shoot up. So that's why it's no liability of the Meera. Okay, so this is the right answer. And which concept that is applied in this case? The concept is bailment. What is the concept? Concept is bailment. So in bailment, we know that if any increase will happen, that increase will be given to the owner. Okay, so this is the right answer. Now, next one. Okay, this is the act name. Just match of the following. Act name, because see, 1 to 2 questions will definitely, they will ask act of the year, because I think 2 times this was asked in your paper. That's why. Company Act, Partnership Act, PSS Act, that is Payment, Settlement and System Act, Transfer of Property, or what? Yes, class, tell me. This is good one. See, Company Act, this is 2013. So Company Act 2013, Partnership Act 1932, this 2007, Transfer of Property, it's a 1882, and Legal Service Authority Act, it's a 1987. So this is the act year. Okay, so this C1 has already come in your exam. So that's why, see, just like one question. So in one types of question, in one number of question, section based, full form, chapter name. So 1 to 2 questions will ask just like that. So that's why please do all the questions. Okay, now write the section. What is right of indemnity holder and continuous guarantee? I'm giving you 15 seconds. In each question, just try to give only 60 to 70 seconds, because 100 question, because we don't have any negative marks, so that's why try to solve all the questions. Okay, try to solve all the questions. Okay, so right of indemnity holder. So this point we have taken from indemnity. This thing we have taken from indemnity. So indemnity, that is given in section 124 of the Indian Contract Act. Okay, so indemnity holder, indemnity have a two party. The first is indemnifier. Indemnifier is there, and this is indemnity holder. So right of indemnity holder, section 125. And what is the right? The right is CDS. CDS. CDS is the name of exam name, Combined Defense Force. But here in this case, C for cost, D for damage, and S for sum. So in all the three cases, cost, damage, sum, in all the three cases, indemnity holder can demand from the indemnifier. He can demand from the indemnifier. Okay, and what is continuous guarantee? First of all, this is given in 129 of your Indian Contract Act. Okay, so these two are the sections, 129 and this is 125. So here class, I can say what is continuous guarantee? So we have principal, debtor, creditor and the surety. So surety is giving that in each, we can say, suppose PD have to collect money, that is rent from the owners. Suppose if PD is not able to take rent, surety will give to the creditor. So this is not only for 1 month, this is for continuous. So that's why this is called continuous guarantee. So guarantor have to act n number of times till it is not revoked. If it is revoked by giving the notice, it cannot be executed. So this is the right answer. 12th one. Okay, now. Okay, so this is your also without option questions. Without option, okay. Number of parties in contract of guarantee. Within how many months minor after becoming major, maximum and minimum number of member in private public 1%, minimum and maximum number in directors, minimum maximum number of partner. This is very good question. In this session, I have highlighted all the types of question for exam. Tell me class. Yes, class. Tell me. This is very important and the good question. See. Number of party in contract of guarantee. So we have a 3 party. This is principal, debtor. This is creditor. And this is surety. Okay. So there is what? We have a 3 parties. Okay. You can say 3. So you have to just write down the 3. So in without option questions now, you have to write in this one. Okay. Within how many months minor after becoming major to declare? Okay, just leave that question. I will explain this question in a very detailed manner. Minimum and maximum number of member in private. So minimum is 2, maximum 200. Minimum is 7, maximum is unlimited. And minimum is 1, maximum is 1 in the 1% company. Is that clear? Okay. Then minimum and maximum number of director in private, public and 1% company. So private directors, private it's a 2, maximum 15. Public 3, maximum 15. 1%, 1, maximum 15. Please see this, because definitely the question will there from this part, definitely. Okay, so please do not ignore these questions. Maximum and the minimum number of partnership firm, this one. So we have maximum number of partners in partnership firm. So we have minimum 2, maximum 100 according to Company Act 2013 and 50 according to Company Rule, that is 2014. Important. This is very much important. And one thing you have to note down, that in your we can say see, if see the number of partner, the number of partner is not given, the number of partners are not given in the Partnership Act, it is given in the Company Act. Okay, that's it. Minimum maximum number of partner in partnership firm and LLP. So in LLP we have minimum 2, maximum unlimited. And C class, in LLP we have a designated partners. So we have a designated partner, that is we have a 2, minimum 2, and maximum that is not there. So this is very much important part, very much important. Okay. Done, class? Now 14th one, this is very much important. Section 30 say that, see, so I think it's a very simple hint for all of you, okay, that you have to write in without option, just like in a number form. See, this is just in a number form. Are you getting my point? This is just in a number form. Okay, so 14, just talk about the section 30 says, suppose if X is the minor, he is suppose 10-year-old and he become a partner. First of all, minor cannot enter into the contract, so minor cannot become a partner. But if he become a partner, so he can take all the benefit. Okay, so if X person, this is Y, X. Suppose now X become major. Major means suppose he become the 18-year. Now after attaining the majority, now this X have a 6-month of time period to declare in the public notice that whether he want to become a partner or whether he don't want to become a partner. And guys, always remember that suppose if he want to become a partner, so if he want to become a partner, now his liability will be start from this date, since he admitted as the benefit of all the partnership. And suppose if he don't want to become a partner, right, in that case his liability will be end here. And one more thing, in 6 months, if he say nothing, In 6 months, if he say nothing, then the partnership will be what? He will be assumed as a partner. Very important concept. So this slide is very much important for the examination point of view. Very much important. Is that okay? I hope so. No doubt in this slide. This is very, very much important slide. Okay. Because I think definitely 5 to 6 questions can become in this slide. So that's why please focus on this part. Done? Now let's move toward the next one. Information about life and liberty RTI. How many acts have been amended after ITA come into picture? Minimum designated partner, partnership form if convert into LLP in which schedule, and minimum punishment in Prevention of Corruption Act. Tell me class. Again, one word question, and this is called without option question. I'm giving you 1 minute time. Tell me guys, 1 minute time I'm giving you. So class, this portion is very much important. Okay, so information about, suppose, see, this question is from Right to Information Act. Okay, and in Right to Information we know that, suppose generally whenever we ask the information from the public authority, so they have to give reply within 30 days. So 30 days is the normal days. Okay, so if information is about life and liberty now, so always remember, if the information is about life and liberty, okay, so in that case what will happen? In that case, within 48 hours the reply should be there. Suppose if a person is admitted in the hospital, so if a person is admitted in the hospital and the patient want to know everything about doctor, treatment, etc., so they have to give reply within 48 hours. Okay, how many act has been amended when ITA come into picture? So when ITA come into picture, the 4 act has been amended. 4 act. These are IPC, which is now it's a BNS. We have a Indian Evidence Act. Okay, and then we have a Reserve Bank of India Act, and then we have a Bankers Book Evidence Act. Okay, so these are the things that is amended when ITA come into picture. Minimum designated partner in LLP, that is 2. Partnership form if converted into LLP in which schedule? See, in schedule 1, 2, 3, 4. Because in LLP we have a, LLP is the simple act. In LLP we have a sections and we have a schedule. In first schedule, if no LLP agreement is there, if no LLP agreement is there, so the LLP have to follow the rules and regulations of first one. Second, if partnership firm wanted to convert into LLP, they have to follow the rules and regulations of the second schedule. In third, if private company want to convert into LLP, they have to follow the rules and regulations of third schedule. And the fourth, if a unlisted public company want to convert into LLP, they have to follow the fourth schedule. So these are the 4 schedule, and in a question they have asked the second one. Okay. Minimum punishment in Prevention of Corruption Act, that is 3 years. Maximum up to 7 years. So again guys, this slide is important. Minimum, this is second schedule they have asked. This 4 Act and 48 hours, C class. So these two slides are very much important for the examination point of view. Done? I hope so, no doubt. Okay, so that's good. Okay, important question. Bailment, usufructuary mortgage, minor as partner, right of indemnity holder, and the valid contract. Tell me class. All terms are important. Okay, now first of all we have to understand the each and every point. So what is bailment? Bailment is basically one person deliver the things to another person for specific purpose. So what is bailment? So bailment is simply when one person deliver the things to the another person for specific purpose, and when the purpose is accomplished, he can take back the goods. So this is what contract of bailment. A very simple definition. This is the contract of bailment. Okay. So bailment is given in section 148. So we have this bailment. Okay. Section 148 of the Indian Contract Act. We have a bailment. What is usufructuary mortgage? Usufructuary, first of all, this one. It's a usufructuary mortgage. So mortgage is basically we are just giving the immovable property as a security. This is called usufructuary. So when usufructuary mortgage, suppose if mortgager is not able to pay the money now, in that case mortgagee can use the rent and profit till the full payment is not done. So this is your usufructuary mortgage. So we have D here. Okay. Minor as a partner, right now we have discussed. So minor as a partner, this is section 30 of the Indian Partnership Act. So we have minor as partner. Okay. Right of indemnity holder, we have discussed. This is 125 of the Indian Contract Act. So this is right of indemnity holder. And valid contract, that is section 10. So section 10 talks about the valid contract, and that is given in the Indian Contract Act. This is given in the TP Act. Okay. So section 10 say if a contract is valid, it should be free consent, the lawful consideration, lawful object, and it should be not declared as a void. So this is your part. Okay. 27. This is the right answer. See. So this is the section base, and just a quick revision that what we have done. Done class? Now next, full form. Suppose if 4 options will come, you have to mark on the full form. Tell me class. And this is your previous year question. This is your previous year question. Tell me. Previous year question. P4, FSDC, and UNICETRA. P4, Indian Contract Act. FSDC, this is module A, and this is IT Act. FIFO, the full form is first in, first out. Okay, first in, first out, that is FIFO. What is FSDC? Council. And this one, it's a United Nation Commission on International Trade Law. So guys, this is the full form. That is important. Okay, so from where it has been taken, I have already highlighted the point. Okay, that's cool. Now, this is important. Now, this is class unseen passage based question. Okay, what is this? This is the unseen passage based question. Now, see. An agreement, any agreement between two and more parties that is enforceable by law is a contract. So here we can see the definition of contract is given. In India, the contract is governed by the Indian Contract Act 1872, exactly, which is a statute containing detailed provision on various aspects of contract, including execution and enforcement. Yes, the various provision contained in the act is known as section. So we know that in every act we have a particular sections. On that sections the rules and regulations are written. Section 2H. So what is section 2H, guys? Section 2H, let's talk about the definition of contract. What is this? Definition of contract. So say contract means an agreement enforceable by law. Thus, the formation of agreement is necessary for contract to come into existence. This is important. Always remember one formula, that offer plus acceptance is equal to promise. Promise plus consideration is equal to agreement. Agreement plus law enforceability, it is equal to contract. So this is the what definition of contract. Is that okay? So contract definition is clear to all of you. Now section 2E define agreement. Now this is the definition of agreement. This is agreement definition and this is the contract definition. Okay, this is the contract definition. Now agreement, see what exactly agreement. Agreement means every promise or set of promises. So one party is making promise, that is called promise. Another party is also making promise, this is called reciprocal promise. So here the promise. So every promise or set of promises forming the consideration for each other is agreement. The formation of agreement take place when offer is made by one party, accepted by other. So here class, one more thing is there, offer definition and acceptance. So guys, in contract now, in contract guys, everyone have to what? First of all offer. When offer will accept, then it's become the contract. So one party should, because we know the formula now, always focus on the formula, that is offer plus acceptance is equal to promise plus consideration is equal to agreement. Agreement plus law enforceability is equal to contract. So this is the definition of contract. So in every contract there must be offer by one party, accepted by another. Under Indian contract, offer is called proposal. If there is no proposal at all, or if no proposal has been made but not accepted, an agreement does not come into existence. So Indian contract regulate various aspects of offer acceptance. Exactly. And when offer is completed, when it's get to the knowledge of opposite party, then it can be accepted. I think this paragraph is not complete, but first of all tell me, this paragraph is, any doubt in this paragraph? Any doubt? And today at 11 a.m. Today class at 11 a.m. do not forget to see the rapid revision. 11 p.m. today. Do not forget to see the rapid revision. Very much important. Rapid revision means a quick revision. Okay. What is rapid revision? That's a quick revision. Okay. That's a quick revision. Done, guys? This paragraph is clear. Next one. Section 2A. Section 2A. Let's first of all highlight the sections. Section 2A, 2B, Section 3. That's it. So now class, see what is given here. Section 2A of Indian contract define the term proposal. So proposal is basically the offer. So what is this? When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain assent of the other, such act abstinence is called proposal. So this is the definition of proposal. Okay. Thus, offer proposal essentially indicate the final willingness. See class, in offer, if anyone is asking question, okay, if anyone is asking question, this is not called offer. Or mere intention is also not called an offer. So for any offer, there should be the final willingness of one person and he want the assent from the another person. That's it. Okay. So that's it. Yes. Okay, so section 2C talks about the promiser. The person who make proposal is called promiser. Section 3 talks about how offer and proposal is made. It states that the party may communicate a proposal, okay, by doing any act or omission by which she intend to communicate such proposal, which affect the communicating it. Section 4 of Indian contract explain when communication of proposal gets completed. So this is very much important. This is section 4. So guys, please see this. Communication of offer gets completed when the proposal comes to the knowledge of person to whom it is made. Exactly. When opposite party get to know now, then only this can be implemented. That's cool. Is that clear? Done? This paragraph is not complete. This is so big one, but it is the easy one. So this act also permit the revocation of offer which has been made by the party. Exactly. It means how the offer can be revoked. This is section 6. So offer can be revoked by giving notice, lapse of time, lapse of reasonable time when no particular time has been, lapse of reasonable time, failure of the acceptor, death or insanity. So guys, these are the 5 points in which the offer can be revoked. Offer can be, guys, revoked. So this is important. Offer can be revoked. Okay. Offer can be revoked. So it is important to know that the offer is different from the invitation to offer. Okay. Offer is different from the invitation to offer. Sometime a person may make statement and give some information. So this is your statement. I think this is a clear. Please, let's do a quick revision. Let's do a quick revision. Hello. Okay. So I hope so this is clear to all of you. Now let's do the questions. Okay. Now first question. If a person If a person goes to the stationery shop, pick up the pen, places a note of rupees 10 in front of the shopkeeper while pointing to the pen or holding it in his hand without saying anything. So A's conduct may be interpreted to mean that he has made dash to purchase a pen from shopkeeper. What is this? Promise, invitation, contract and offer. Tell me class, a very good question. What A have done in this case? What A have done? What A have done? So here class, the A have done, that is the offer. What A have done? A have done the offer. Okay, it's so because already the contract is done. So A have put the offer, then the contract is made. Cool. Now, if A send a letter by post to B containing the offer, the communication of such offer shall be completed when the letter has been received and read by B. Which statement is right? True statement. Letter is eligible, undesirable. B has no reason to accept the offer. This is a true statement. That's a true statement. Okay. Suppose if A offer at 1st June through the post. So this is communication of offer. 3 June, the letter reached to the B. So what is 3 June? So 3 June is simply that's the offer is completed. Okay, that's cool. If A made an offer to B, before accepting the offer, B finds out that A is clinically proved insane. What happened to the offer? Offer will be not finished. A's insanity will scare. Okay, the offer will stand revoked and the offer may be passed to the another party. Tell me class, what is the right answer? What is the right answer for this question? This is very good question. If A made the offer to B, before accepting the offer, B finds out that A is clinically proved insane. So guys, if A is clinically proved insane, so here, as we know that for any contract, the parties must be competent to contract. The party must be competent to contract. Okay, so that's why in this case, the offer will be stand revoked. So for 33, C will be the right answer. C will be the right answer. Okay, cool. Next, the display of goods by a shopkeeper in his shop. It is invitation to make offer, contract, proposal or sale. Display of goods by the shopkeeper in his shop. What exactly this is? Yes, tell me guys, the display of goods by a shopkeeper. So display of good is always invitation to offer. So A is the right answer. It's the invitation to offer. Got it guys? It is invitation to offer. Done? Now what is the basic difference between invitation? What is the difference between invitation to offer and offer? So what is the basic difference between invitation to offer and offer? That is very simple. Invitation to offer is simply, suppose if a sale is going on. If a sale is going on, so what is sale? Sale is basically, it's a invitation. Now suppose if Nikkita ma'am accepted this sale, that 90% sale in a sari. I accepted this. This is called invitation. This is called now it is invitation. When I reach to the shop and I take the sari, that is called offer. Now I'm just making the offer that I want to purchase this sari. Okay, so this is the difference between invitation to offer and the offer. Okay, again guys, a paragraph based question, that is important. Okay, a paragraph based question. See, an agreement. What is this? An agreement without free consent. Okay, an agreement without free consent can be enforced only at the option of whose consent is not free. Okay, when an agreement without free consent. So class C, we know that for any contract there must be free consent of the party. So what is free consent? Free consent means simply without any pressure. Okay, so if any contract is done without coercion, without fraud, without undue influence, without mistake, and without coercion, fraud, undue influence, misrepresentation, and mistake. In all the cases, the contract will be voidable. So what is voidable contract? Voidable contract is simply when one party have right to breach the contract. This is called voidable. Okay. So an agreement without free consent can be enforced only at the option whose party consent is not free, where one of the party to a contract was in a position to dominate the decision of other party. The contract is enforceable only at the option of party who is in position to dominate the decision. So this thing we are talking about the undue influence, because in undue influence, suppose if a person is there, he is saying that if you will give me your all property, you can easily pass your exam. It means that is using the power, that is dominating power. So in undue influence, one party dominates the power to the another person. In the case of fraud, where party to a contract knows or believed to be fact to be true, but conceal it actively from the other party. Okay, mere silence as to fact likely to affect the decision of person to enter into contract is not a fraud. When consent to the agreement is caused by coercion, undue influence, fraud, misrepresentation, the agreement is called voidable. So this is very much important. What is voidable contract? So voidable contract is basically where one party have an option to breach the contract. Okay, suppose if X person is doing coercion with the Y person, so Y person have a right to breach the contract, because see, in all the 5 types, the contract is done. Now it's totally depend upon the opposite party. It's totally depend upon the opposite party that whether he want to breach the contract or not. Suppose if he will not breach, the contract will be go as it is. Getting my point? This is the right answer. Okay, now knowingly making a false statement to a person with the intention to deceive him into contract is called fraud. Making a false statement while believing it to be true is called misrepresentation. So what is the basic difference between the fraud and misrepresentation? See, in fraud and misrepresentation. In fraud, suppose if Nikkita ma'am is saying with a guilty mind that my car is very up to date, but actually I was hiding that the brake is not in a good condition. Nikkita ma'am is doing fraud. But in misrepresentation, if I just want to sell my car, but I actually don't know the brake of my car is not in a good condition, and I just sell the car, this is misrepresentation. In both cases, the contract will be void, but in fraud, the opposite party can also ask the compensation. But for misrepresentation, you cannot ask the compensation because the person have given the car in an innocent way. That's it. Okay. Yes, class. Any doubt in this paragraph? Any doubt, class, in this paragraph? I think that is clear to all of you. Done, class? Okay. So I hope so. This is clear to all of you. Now the next one. Okay. Whoever commit any act which is forbidden by IPC. What is this? Indian Penal Code. Now this is known as Bharatiya Nyay Sanhita. It's a BNS. Okay. 2024. So any act forbidden by IPC with a view to obtaining the consent of any person to enter into agreement. He cannot get the agreement enforced by law, but the person whose consent has been obtained may get agreement enforced by the law. So the IPC, that's TOXI. IPC is what? IPC where offense definition is given and its punishment is given. And its punishment is given. That's it. This is called IPC. Okay. Mere silence. Suppose in a fraud, suppose in the case of fraud, I have a car, I just want to sell the car. If it's my duty to just say everything about my car and I'm keep silent, it's my wrong act. I will be liable. This is called fraud. But mere silence as to the fact likely to affect the willingness of person to enter into contract is not a fraud unless the circumstance of the case such that on close examination it is found the duty of person keeping silent to speak and unless his silence equal to speak. It means, see, if it is my duty, okay, if it is my duty to keep silent, if it is my duty to keep silent, so in that case, if I say nothing, I am not liable. But it's my duty to speak. On that time, if I am silent, I am liable. So this is very, very much important question. Okay. So the act using threat to force another person to enter into contract called coercion. So here we have just defined the term coercion. Coercion means to threaten someone. Okay. Now see. A obtains the consent to B to enter into agreement by putting a gun on his girlfriend. B can enforce agreement. B cannot force the agreement. A can force the agreement. Neither A nor B force the agreement. Tell me, guys. Very important. So here B will enforce the agreement because A have done the coercion. So this is the right answer. Okay. Now next. A doctor asks his patient to make a payment of 10 lakh for treatment of his fever. The patient paid the amount 5 lakh and promised to pay remaining 5 after the treatment. After treatment, the patient recovered from fever. The doctor demands remaining amount from the patient. The patient refused to pay. The patient refused to pay. Contract is enforceable against doctor. Contract is enforceable against patient. Contract is not enforceable and contract is not enforceable against the patient. Good question. So guys, in this case, okay, the doctor patient, the contract is enforceable against the doctor, not patient, because patient have to pay the price. Okay. So contract is enforceable against the patient because patient have to give the remaining amount. Okay. Next. A sell to B. A sell to B a horse which A know to be unsound. A say nothing to be about unsoundness. This is your previous year question. This is the previous year question. Okay. First of all, I'm going to tell you the hint. This is the hint. Mere silence as to fact, likelihood of willingness is not fraud. This is the line because the question which I'm showing you, this is the line where answer is there. This is the line where answer is there. Now tell me the right answer. Done. Tell me. A say nothing to B about the unsoundness of horse. Tell me. A say nothing to B about the unsoundness of this. So here class in this case, A has not committed the fraud. Why A has not committed the fraud? Because mere silence, where it's your not duty to say something. In that case, A has not committed the fraud. Not committed the fraud. So A has not committed the fraud. This is important. Because in the fact also, do not assume. Never apply your prior knowledge in the BRBL subject. Never apply. Okay, so C will be the right answer. Okay, while taking life insurance policy, in reply to the question by insurance company during the inquiry in his proposal, Zamir deliberately, it means we can say deliberately conceal the fact of his medical treatment for serious ailment which he had undergone only a few weeks ago. The act of Zamir did not amount to fraud. The act of Zamir amounted to innocent misrepresentation. Act of Zamir did not amount to misrepresentation. Concealment of fact amount to fraud. In fraud, in misrepresentation. In fraud, the person doing intentionally. In misrepresentation, the person is doing innocently. That's the basic difference. Innocently. Okay. So the concealment of fact by Zamir amounted to fraud. So this is the right answer. D is the right answer. Is that okay? Cool. Next. X threatened to gun down Y if Y does not sell his property that is of 20 lakh for rupees only 1 lakh. As a consequence, Y agreed to sell demand by X. Which of the following is correct? X threatened to gun down Y. Threaten. This is X person is showing the quotient. X person is showing the quotient. So there is an agreement between X and Y which can be enforced by court of law. There is a contract between X and Y, agreement between X and Y. So here in this case, the contract between X and Y is voidable at the option of Y because the quotient is done by the X person. That's why. So this is the right answer. Okay, next. The director of a company issued the prospectus stating that they had the authority to run tramway with steam. The director honestly believed that Board of Trade would be grant sanction to the company for the same. The Board of Trade later refused to grant the sanction. The directors are liable for fraud. The directors are liable for misrepresentation. Fact is insufficient. None of the above. See, fraud is the wrongful act. Misrepresentation is also wrongful act. Fact are not sufficient. None of them. What the question they are asking? This is not the right answer. Facts are not sufficient. Facts are not sufficient what they are asking. Okay. So here C will be the right answer because fact is really not sufficient. Done? Now, Mr. A customer of XYZ bank, applied for personal loan of 5 lakh. He submitted all required document, was assured the sanction within 7 days. Okay. However, bank delayed the processing the loan and sanction after 30 days without proper communication. Meanwhile, Mr. A had to borrow money from the private lender at a high interest rate due to delay. Aggrieved by the bank's inaction, Mr. A filed the complaint with the banking ombudsman under this act. alleging deficiency in services, financial loss. During the hearing, bank argued that due diligence took time due to the internal policy check and no written communication of 7 days was made. Mr. A maintained that bank had a duty to act fairly and promptly. That's the fact. That's the fact, class. Okay. Now the question is, which of the following is the most appropriate outcome for this act? That is integrated ombudsman. The complaint will be rejected as there was no written commitment. The complaint may be upheld there was deficiency in services. The complaint will be dismissed as loan was eventually sanctioned. Ombudsman will ask A to file against consumer court. See the fact, then give me the answer. See the fact, class. See the fact and then give me the answer. So class, this question is very much important, okay? This question is very much important. So here, which of the following is the most appropriate? So here class, see, So guys, in this case, as we can see here, suppose if the bank have a particular time limit. So in that time limit, but obvious, they have to give the reply, but they have not given the reply within 30 days, okay? So that's why complaint will be upheld as there was deficiency in services due to unreasonable delay. So this is the right answer. Okay, because that line show. Bank delay the processing loan sanctioned after 30 days without proper communication. This is the wrong thing which is done by the bank. Okay, that's it. Now class, Mr. A, a banker, entered into the loan agreement with Mr. B. Okay, Mr. A found that B's business secret were illegal and used this information to threaten Mr. B into signing the agreement. Mr. B later approached the court to void the agreement, claiming coercion. So how Mr. B entitled to void the contract? So is B is entitled to claim to void the contract? Yes. 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 Only if constitution is legal. Yes, consent was not free to coercion. This is the right answer. See, there are two words. First is void agreement and the second is void contract. So what is the basic difference between void agreement and void contract? So void agreement from initially invalid contract. Initially it is valid, but later on it is void. So that's the basic difference between void agreement and this. So void agreement is simply, suppose if any minor is there, right? If a minor is there, if drunken person is there, if they are doing any contract, that will not call as a contract. So this is void agreement. That is void from the very beginning. Okay. And what is void contract? So void contract is basically from initial it is valid, just like if X person book a hotel for his marriage, that is going to be held in 30th June. But after, we can say, 20 June, the government say the lockdown will be there. Now it is not possible. Now it is not possible. So initially it is valid, but later on it is void. So this is called void. This is called what? Void contract. So okay, so void contract, from initial it is valid, later on it is void. That's a very simple definition. Okay, now cool. Next. ABC Bank granted a loan to XYZ Limited. On default, the account was classified NPA. The bank issued 60-day demand notice under SARFAESI Act. The borrower did not respond. Bank decided to take possession of the secured asset. So what is the correct step for the bank under the SARFAESI Act? Tell me, class. Always remember, under SARFAESI, bank is issued 60-day demand notice, that is given in section 13 clause 2. Guys, this is the right answer, because if section 13 clause 2 will not apply, okay, if section 13 clause 2 will, if section 13 clause 2 will not apply, so section 13 clause 4 will apply. So what is section 13 clause 4? That's taking possession of the assets. So this is the right answer. Okay, this is the right answer. Now, a director of Z Limited found misusing company funds for personal travel. The shareholder filed a complaint, demand action as per Company Act. What action can be taken under the Company Act against the director? No action, it's a personal matter. Fine, imprisonment, warn the director, remove him from shareholding. Because see, in the Company Act, we know that the company have a different legal existence and the member have a different legal existence. So what action, okay, can be taken under the Company Act against the director? So here we have fine and imprisonment. Okay, so this is the right answer. M N formed LLP. M borrowed 10 lakh from a bank for personal reason using LLP name. N was unaware, did not authorize the borrowing. Who is liable to repay the loan? So C class. In LLP, always remember, suppose if P1, P2, P3, if 3 partners are there, if P1 have done the wrongful act, so for that wrongful act, LLP is liable, not P2, P3. So it means the mutual agency lies between the partners and the LLP. So M and N form the LLP. M borrowed 10 lakh for the personal reason by using LLP name. N was unaware, did not authorize. So who is liable to pay? So here it's a M and LLP, because mutual agency lies between partner and the LLP. And in the case of partnership, if P1, P2, P3, so in the case of partnership, if P3 have done the wrongful act, in that case, all partners are liable. So this is the crux of the Indian Partnership Act. Cool. Next. A customer applied under RTI to a private bank for detail of his loan account and its classification. The bank denied, saying RTI doesn't apply. Is bank is justified? Is bank is justified, class? The customer applied under RTI to a private bank for detail of his loan account and its classification. The bank denied saying RTI does not apply. Bank is justified because we know that RTI always apply to a this. So yes, private bank is not under RTI. This is the right answer. It's the reality. The private things will not apply in this case. Okay. Next one. A partner in XYZ firm took a loan for firm's expansion without other partners' consent. The firm refused to, citing the lack of approval. Is firm liable? Is not. So class, we know that in the Indian Partnership Act, if P1, P2, P3, P4, if 4 partners are there, they are doing the act. In that case, if P1 have done the wrongful act, all other partners are liable. And if I'm saying all other partners are liable, it means partnership firm is liable. So is firm is liable? The partner in XYZ took a loan for firm expansion without other partners' consent. The firm refused to, citing the firm refused to repay this one. So firm is liable class. So yes, the partner has implied authority. Yes. Okay, so this is the right answer. Next, a customer complained the unauthorized ATM withdrawal and the poor grievances redressal by bank. He approached the consumer forum. Can he do so? Can he do so? No, banking not covered. Yes, bank is the service provider. No, it's a criminal case. Yes. What he can do under Consumer Protection Act? So class, the answer is yes. Why it is yes? Because see, in Consumer Protection Act, we know that the consumer is a person, okay, who avail the service and who purchase the goods. That's it. So that's why the banking services comes under or covered under this act. Okay, next. Mr. X took a loan from bank by depositing his property till lease without registration. He failed to repay. Bank initiated the recovery. So guys, tell me what types of mortgage is this? Already given you the hint in this case. So class, this is very important. Okay. See, the types of mortgages, but obvious, that is important. So section 58 clause A, let's talk about the definition of mortgage. Okay. Section 58 B clause, that is simple mortgage. C, conditional mortgage. D, usufructuary mortgage. It's a E, English mortgage. It's a F, that is equitable mortgage. It's a G, that is your last one, anonymous mortgage. So here, without registration, depositing the title deed. So this is your what? Equitable mortgage. So when equitable mortgage is the only mortgage where no registration is required. That is important. No registration is required. Okay. Now, next. A check issued by Y to Z was dishonored due to insufficient funds. Z issued a legal notice. and wife failed to respond within 15 days. What remedy is available? Z, after dishonor, always remember whenever the check is dishonored, the complainant have to give the legal notice. Okay, and after legal notice, if wife fail to respond or pay within 15 days, so always remember they can file the complaint under section 138. So what is 138? Let's talk about the dishonor of check. So this is very much important. Okay, this is very much important. Done class? B is the right answer. Cool. Done. Okay, so let's take a 3 minutes break only. Okay, 3-minute break. Done? Yeah, I hope so. My voice is audible. So now let's start with the next one. Okay, cool. Next question. See, first of all, please quickly revise the, the types of prospectus and the mortgage. This is very, very much important. Okay. Now let's do a quick revision. So what is deemed prospectus? I have already highlighted. So deemed prospectus, see, prospectus is just like a brochure of a company. That is called prospectus. Okay. So when a company allow or agree to allot any securities to the company, the document is considered as a deemed prospectus via which offer is made to investor. Important. A red herring does not contain all information about the price of the security offered and the number of security to be issued. This is important. Self prospectus, institution offer one and more security to the public. An abridged containing all salient features of the prospectus specified by the SEBI class. Let me just please read all the things because all these points are important. All these points are important. See, allow or agree to allot any security to the company. Does not contain all information about price of this. Self prospectus is issued when company or any FI offer one and more security to the public. Abridged containing all salient feature of this. So this is very much important about the types of prospectus. So prospectus is basically the brochure of a company and every company have to make it. Okay, so this is important. Okay, so I hope so this is clear to all of you. And now let's do a quick revision of kinds of mortgage, because see, this point is also very much important, the types of mortgage. Okay, so simple mortgage, mortgager is personally liable to pay. Mortgager is personally liable to pay. Mortgagee has right to sell if mortgager is not able to pay the money. Okay, conditional sale. A condition is put up that if mortgager is not able to pay the money, the conditional sale will become the what? It's become the sale deed. Okay, so this is your given here. Condition that it will be retransferred to the mortgager upon repayment. What is usufructuary? Mortgagee takes possession of property, enjoy its rent profit until loan is repaid. English mortgage. The property is transferred to the mortgagee upon full repayment and retransferred to the mortgager. Mortgage by deposit title deed. The mortgager deposit property title deed with the mortgagee as a security. Because mortgage by deposit of title deed is the only deed where no registration is required. Okay. And what is anomalous? Anomalous is simply that doesn't fall under any of the following category, potentially a combination of different types. So anomalous mortgage, two and more types of mortgage is called anomalous mortgage. So from prospectus and from types of mortgage, the question will be definitely come. Is that clear? The question will definitely come. Cool. So this is clear. Now 51. Okay. This company, this is the MEF Limited. MEF Limited company failed to repay dues and the creditor filed application under IBC, that is Insolvency Bankruptcy Code. NCLT accepted the application, appointed the IPR, that is Insolvency Resolution Professional. Insolvency Resolution Professional. What happened next? Company is dissolved, liquidation start, moratorium is declared, or credit rating is improved. This company failed to repay dues. Creditor file application in IBC. Okay. Moratorium is different. So moratorium is basically the relaxation period. Always remember in IBC, if I just tell you the one thing in IBC now, first of all, insolvency resolution process will be go on. If it is not solved, then we will start the liquidation process. This is very much important. Okay, next. Statement 1, statement 2. A minor contract is void ab initio under Indian contract. So what is void ab initio? It's a legal maxim. It's a legal term. It means void from the very beginning. Okay. Because see, whenever this type of question will come now, please read out one and then just add on because minor can be held personally liable for benefit received under the void contract. This is the right. Minor cannot be held personally liable. So that's why, guys, the right answer will be only first statement is wrong. Right statement. Okay. So void from the very beginning. So this is the right statement. Cool. Next. A public company must have minimum 7 members. Exactly. Because article of association is mandatory document for the public company. Article of association is mandatory for a public company. Article of association. Okay, so this is yes. Okay, so both statements are correct. So here A is the right answer. But for public company, it is not necessary. So that's why this is the right answer. Okay, next. Next question. Yeah. A check return due to insufficient fund can attract section 138 because we know that section 138 talks about the dishonor of check. Because the payee must present the check within 6 months from the date it is drawn. So only first is right, both is correct or what? Within 6 months. Right now it is changed. So the limitation is 3 months. So that's why only first statement is correct. So A is the right answer. Cool. Under SARFAESI Act, bank can take possession of secured asset without court intervention. Okay. Only unsecured creditor can invoke SARFAESI Act. This is totally a legal fact. This is totally a legal fact, guys. This is totally a legal fact. So here, SARFAESI bank can take possession without court intervention. This is the right statement. This is the wrong because SARFAESI Act always apply to the secure creditor. So that's why only first statement is the right statement. Okay, next. A shopkeeper, Mr. A shopkeeper display a laptop in his shop window with a price tag 50,000. Mr. B see the tag, enter the shop, demanding to buy laptop at the stated price. Mr. A refused, stating the price tag is outdated. So can in Indian Contract Act, Mr. A is bound to sell the laptop at rupees 50,000. Is Mr. A bound to sell the laptop at rupees 50,000? Mr. A is bound to sell the laptop at rupees 50,000. Mr. A bound to sell the laptop at rupees 50,000. So class C, this is simply invitation to offer. Okay. So in this case, it's invitation to offer. So here B will be the right answer, because invitation to offer is different from offer. This if the sale is there and if the item is displayed in the board, so that's come under the what? Invitation to offer. So that's why B is the right answer. Okay. Next, a director. What is this? A director of XYZ Limited approve a loan to the related party company without informing the board. Later, the company suffered losses due to loan turning into the bad debt. Which duty of director has been violated under the Company Act? Tell me, class. And see, we know that for a company, the company have a different legal existence, because company is a artificial legal person and the member have a different legal existence. So which duty of director has been violated under Company Act? Yes, class. So which duty of director has been violated under the Company Act? So here we have seen promote company success. No. Duty to attend the board meeting. So this is the right answer, because if you are director, it means every decision should be taken in the board of director. Okay, by the board of director. ABC Bank issued a demand notice under section 13(3) of SARFAESI Act for 10 lakh. The borrower failed to repay. The bank took possession of assets without intervention of the court. So under which section can the bank take possession of the secure asset? Section 13(4), 14, 31, section 13 clause 3. This is very much important. In SARFAESI, section 13 clause 2, section 13 clause A, and section 13 clause 4. That is important. Yes, class. Section based question will definitely, 1 to 2 question will definitely come from the section based. So which of the following is the right one? Bank take the possession. This is section 13 clause 4. Okay, that is important. That is important. Okay, a customer file RTI with RBI. Okay, seeking information about ongoing inspection report for a private bank. RBI denies the request citing exemptions under RTI Act. Which section allow this part? Exemption in RTI is given in which section? Exemption in RTA. Okay, so we have which section RBI withholds such information. So we have your section 8 clause 1e. Okay, so this is given. Section 8, 9, 24. Let's talk about the exemptions. Okay, that's cool. Okay, a bank failed to reverse a fraudulent transaction reported by customer within the time. The customer filed complaint under Consumer Protection Act claiming deficiency in the service. So in this situation, that's covered under the deficiency in the services. Tell me, in this situation, it's covered under the deficiency in the services. Yes, no, what? Yes, because banking is a services. No, because bank is not liable. Yes, but only if fraud is proven in court. No, consumer consented to the transactions. Tell me, class. Because banking is a services. See, in the Consumer Protection Act, if we are talking about the consumer, so consumer is that person who is taking service, okay, and who is purchasing the goods. If any defect will come in goods and services, then you can claim. So here A is the right answer. Cool. Next, a 17-year-old boy took a loan of 5,000 from a lender, signed a promissory note. Later he refused to repay the citing minority. So is contract is enforceable or not? If the minor is there, minor. Is contract enforceable? Yes, no, yes, no. In the case of minor, no, one is a very famous case, that is Mohri Bibi versus Dharmodash Ghosh case. Mohri Bibi versus Dharmodash Ghosh case is one of the famous case where it was held that any contract done by the minor is totally void. Void ab initio. So contract is enforceable? The answer is no. Why? Because minor is void. So any agreement which is done by minor is void ab initio. This is the right answer. Okay. Next. ABC Limited, it's a company, wants to enter into the new line of business that is not mentioned in the MOA. The AOA allows such business activity. So guys, before doing this question, we have to understand what is MOA and what is AOA. So Memorandum of Association and Article of Association, both are the public documents. Okay. Memorandum of Association, that's a important legal document. It's a charter of a company. It's talk about the relationship between company and the outside world, okay? And then you cannot change anything in a memorandum of association easily, and it contains 6 clauses, that is name clause, liability clause, capital clause, name, liability, capital, register clause, object clause, and the association clause. So these 6 clauses every company have to mention in their MOA. Okay, and article of association. If I say article of association, so article of association is basically, I can say article of association. Let's talk about the internal rules and regulations of the company. So in this question, This company want to enter into new line of business that is not mentioned in MOA. Article allows such business. Can company say no? Because we know that MOA is supreme. See, Company Act, right? Company Act, MOA. It means MOA is inferior to Company Act and AOA is inferior to MOA and the company. So, AOA have to follow the rules and regulations of MOA and Company Act. And this MOA, they have to follow the rules and regulations of the Company Act. Okay. So, MOA is the supreme. Next, a railway company, okay, a railway company deliver the goods at a wrong address. The receiver used goods thinking they were sent by his relative. Later, actual owner demand the payment. So, what kind of legal obligation arise? Tell me, class. What kind of legal obligation arise? That's a good question. Whenever I just teach the legal questions, now I enjoy. Why? Because these legal questions are the common sense questions, and this is the only subject where practically all question you can see in your banking day-to-day life. So a railway company deliver goods at a wrong address. The receiver used the goods thinking they were sent by a relative. Later actual owner demanded the payment. So what kind of obligation arise? So guys, this is, it's called the quasi contract. So first of all, we have to know each and every point. If I'm saying tort, so what is tort? Tort is basically, it's a, for any wrongful act, we have a remedy. This is called tort. Express contract, that is written, that is oral. This is called express contract. Okay. Quasi contract, it's okay. Criminal liability, if you are if you have done the wrongful act. And what is quasi contract? Quasi contract means initially the contract is, see, I'm just telling you a very simple example to understand the quasi contract. In quasi contract, initially, no intention to enter into the contract. No intention to enter into the contract in quasi contract, right? But later on, you have to enter into the contract. This is called quasi contract. A very simple definition. This is called a quasi contract. Cool. So suppose by mistake, if delivery boy delivered pizza in Sneha ma'am house, but I have ordered, but Sneha ma'am eat. So if Sneha ma'am is eating, it means initially she was thinking that someone have gifted pizza. But later on, when she come to know that this pizza belong to Nikkita ma'am, so now she have to give money, or otherwise she have to give the payment. So this is the example of quasi contract, a very simple definition. Cool. Next, Mr. P issued a check for 1 lakh to Mr. Q. It was returned unpaid due to insufficient fund. Mr. Q issued a legal notice within 20 days. Mr. P failed to respond. Which section the P is liable? Under which section, guys, the P is liable? Tell me. Yes, class, tell me. So in which section the P is liable? So this is your section 138. Okay, the P is liable. So guys, please do all the questions by yourself. Okay, by yourself. This is very much important. In an LLP, one partner committed a fraud. In LLP, one partner have committed the fraud. the LLP incurred a loss due to the regulatory fine. Other partners were unaware and not involved. So who is liable for the fraud? So we know that class in LLP, okay, suppose if P1, P2, P3, if three partners are there, right? So in this case, always remember, if P1 have done the wrongful act, if P1 have done the wrongful act, so in that case, what will happen? So in that case, class, if the wrongful act is done now, so LLP is liable, not other partners are liable. This is very much important. So in this case, in LLP, one partner committed fraud, the LLP incurred loss due to regulatory fines, other partners were unaware, not involved. Who is liable for the fraud? So here, no. No. LLP is liable. Okay. C is the right answer because LLP and that part, but that is not given because see, the mutual agency relationship arises between the partners and the LLP. That's it. Okay. Now, important. This is question of surface C. Okay. Now see, ABC Bank had a ABC Bank have a granted term loan of 1.2 crore to Shakti Tools. That's a company name. A small scale industrial unit. Okay. The loan was secured by equitable mortgage. So what is equitable mortgage? Where no registration is required. Okay. And this is also known as mortgage by deposit of title deed. Okay. So this bank has granted a term loan of 1.2 to this company. So this is the bank. ABC Bank is there, granted a loan to this company. It's a private limited, 1.2 crore. Okay, the loan was secured by equitable mortgage. Factory land and building is given as a security. Okay. So here, after 15 months, the account become NPA as per RBI guidelines due to the non-repayment of dues. Okay. The outstanding loan amount at this stage was 1.05 crore. Okay. ABC Bank issued demand notice under section 13(2) of SARFAESI asking borrower to clear dues within 60 days. That is very important section. The borrower did not respond to the notice nor they did repay the loan. Subsequently, bank took the symbolic possession of secured asset under section 13 clause 4 of the act, published the possession of notice in 2 newspapers. The borrower approached DRT claiming the notice was invalid due to the procedural inflaw. So class C, first of all, I would like to highlight things that is very much important. So we have section 13 clause 2 that is important. We have section 13 clause 4 that is important. 2 and section 13 clause 4 is important. Okay. And then this is the borrower approached the DRT. So within 45 days, the borrower have to approach the DRT. So section 13 clause 2, it's talk about the demand notice. And 13 clause 4, symbolic possession. So one word to remember. That's it. Is that clear? Done, guys. So now, what is the minimum amount of default required for a bank to invoke SARFAESI? Minimum 50,000, 1 lakh, 1 lakh or 20% of principal and interest, or 1 lakh and classified as NPA. So here we have minimum 1 lakh. So this is very much important. So SARFAESI will always apply if the amount is minimum 1 lakh. Okay. Next. Under which sections of SARFAESI Act demand notice issued to the borrower. This paragraph, guys, this paragraph is very much important. Very, very important, this paragraph. Question will definitely, because see, from surface in module C and from contract from module D, always so many questions will ask. So, demand notice, section 13, clause 2. Okay. Next, what is the time limit given to the borrower to respond the demand notice under section 13, clause 2? 30 days, 45 days, what? So here class, this is 60 days. Okay, that's a simple legal fact. To challenge the bank possession action under surface C, the borrower can file appeal. So the borrower okay, to the DRT. This is the right answer. Okay, this is the right answer. Okay, what is symbolic possession in surface means? Physical takeover by police, legal notice served but no physical possession, borrower voluntarily vacate property, and auction of the property. Tell me class, what is meant by symbolic possession in surface context? Symbolic possession. Legal notice served but no physical possession. This is called symbolic, and we can also call it constructive. We also called it constructive. Okay, next. This act extend to what? This is the Recovery of Debt and Bankruptcy Act 1993. It extends to whole of India except Jammu Kashmir, whole of India excluding the state of Jammu Kashmir. So this act will apply to whole of India. Always remember, in 2019, right? In 2019, some under Article C, we know the Article 370 of Constitution of India. So Article 370 of Constitution of India talks about that the Jammu Kashmir have a special, we can say the special protection is provided under section 370 of Constitution of India, but in 2019 it is removed. Okay, so that's why this act applied to the whole of India. So this is the right answer. The chairperson of appellant tribunal, the presiding officer of tribunal, the recovery officer of another officer, an employee of this, shall be deemed to be what within the meaning of section 21 of IPC. They are called as a public servant, they are called as a government servant, private servant, or none of the above. They will call as a public servant. So this is the right answer. They will call as a public servant. Is that okay, class? Done. Next. How the recovery officer shall proceed to recover the amount of debt specified in the certificate. That's cool. See, we know that we have a DRT. So in DRT, we have a presiding officer. So presiding officer will give the recovery certificate. Okay. And that certificate will be executed by recovery officer. Okay. So here, taking possession of property over which security interest is created or any other property of the defendant and appointing receiver for such property is still the same. Attachment and sale the movable and immovable property, arrest the defendant and his detention in prison, or one and more of the above options. Appointment of the receiver. So what are the ways in which the recovery officer will take money from the borrower, because because recovery certificate will be issued by that person. So how recovery officer will proceed to recover amount of this? So here we have all option. So all are the way in which we can take money from this one. Okay. The tribunal and the appellant tribunal shall not be bound by the procedure laid down by IPC, Code of Civil Procedure, Indian Evidence, or Code of Criminal Procedure. So tribunal, appellant tribunal are not bound by the procedure of CPC. See, in India we have a two types of law, that is the civil and we have a criminal. Civil and criminal. Okay. Civil X versus Y. Criminal X versus state. Is that okay? So that's why civil procedure code, because see, all the banking matter always come under the civil procedure. So that's why the tribunal, appellant tribunal are not bound by the procedure which is laid down in the CPC, because in civil code we just follow CPC. In criminal code we follow CRPC. Okay. Next, any proceeding before tribunal or the appellant tribunal shall be deemed to be the what? Judicial proceeding within the meaning of section 193-228. Tribunal or appellant tribunal shall be deemed to be the civil court for all purpose. Both A, B is correct. None of the above is this. Yes. Any proceeding before this, and this shall be deemed to be the exactly. They shall be deemed to be the civil court and judicial proceeding. So both A and B is the right answer. Okay. Both A and B is the right answer. Next, how the interim or final order, interim means that is temporary, how the interim and temporary order passed by tribunal or appellant tribunal shall be served on the party. First, any interim or final order passed by tribunal, appellant tribunal shall be transmitted by electronic mail to the registered address of the party. Any interim or final order passed by tribunal, appellant tribunal shall be displayed on the website. Order passed by tribunal, appellant tribunal shall be handed to the concerned party. Both A and B is the correct one. Yes, class. How the interim and final order passed by tribunal will be served on the party. Electronic mail. Okay, electronic mail is there. Displayed on the website. Both A and B is the correct one. D is the right answer. Okay, that's cool. Next, a person shall not be qualified for appointed as a chairperson of appellant tribunal unless he is the member of Indian Legal Service, presiding officer, qualified judge of High Court. All the options are correct. This is very much important. Always remember, if we talk about the DRT and we have a DRAT. So guys, in DRT, we have a presiding officer and in DRT, we have a chairperson. Okay. The tenure is 4 or 70 years and this is also 4 and 70 year. Okay, then in DRT, suppose district judge can become the presiding officer, and here high court judge, Indian legal service, 3 year at least you have to work. Okay, and then Indian legal service, then presiding officer at least for 3 year. Resignation, 3 month prior notice, 3 month prior notice. So that's why all the options are correct. So always remember this one. And tenure is also important, because tenure sometime they just ask. This is the amended one. 4 year and the 70 year, that is the amended one. Previously it was different. So just learn the latest one. So that's why D is the right answer. Cool. D is the right answer. Next. Lok Adalat is basically means what? What is Lok Adalat? Yes, guys. Lok Adalat basically means what? Women's court, man's court, people court, children court, what? Lok Adalat basically means what? So we have Lok Adalat. It means basically it's a people's court. Okay, this one. The award made by Lok Adalat. So what is award? Award is basically the final decision. This is final decision. So the final decision which is made by Lok Adalat is deemed to be the decree of civil court, like arbitration award deemed to be the decree of civil court, effective as the arbitral award and not binding on the party. Always remember, whatever the award which is done by the Lok Adalat, first of all, that is the binding on the party, binding, and no appeal lies against this award. No appeal. So that's why the award made by Lok Adalat is deemed to be the decree of civil court. That's a law. So B is the right answer. Okay. Next. Which article of Constitution of India contain various provision for settlement of dispute through the Lok Adalat? 14, 19, 39A or 21? Which article of Constitution contain the various provision for settlement of dispute through the Lok Adalat? 14, 19, 39A or Article 21? So here we have a Article 39A. 14 talk about right to equality. 19, it's a free speech. 39A, that's talk about free legal aid. 21, it's a right to life. So Article 14, 19, 21, it's a fundamental right. Okay. So that's why this C is the right answer. 39A is the directive principle. That's come under the directive principle of state policy. So this is the right answer. Now, this is very much important. This question is from Consumer Protection Act 2019. Tell me this limitation period and how much appeal days for this one. I'm giving you 1 minute time. 1 minute class. So class, let me explain you. This is very much important question, okay? Do not skip this question. So suppose if any person, okay, this is suppose Shushma ma'am is there. Suppose Rahul sir is there. So Rahul sir, you are the consumer. If you want to file the case to the district commission, you have a 2-year of limitation. If you want to file the case to the state, 2 years is the limitation. If you want to file directly case to the National Commission, again you have a 2-year of limitation. Okay, from district to state commission, we have 45 days. From state to national, we have 30 days. From national to Supreme Court, we have a 30 days. See, filing case district, we have a 2-year, 2-year, 2-year of limitation. Appellant, 50%. It means suppose from district to this one, if you want to go, you have to pay 50%. From state to national, you have to pay 50%. For national to this, no need to pay. Important. Cool. This is very much important. Okay, because see, this type of questions can become in the form of without option. So please remember these questions. Now, which of the following cases filed in the state commission? See, in your syllabus, you have a 2019 act, okay, because this act is basically of 1986, but you have a amended one. So when the value of good and services questions along with a compensation claim is exceed 1 crore but does not exceed 10, this is exceed 20 lakh, not exceed 2 crore, 40 up to 1 crore, none of the above. I'm just writing 2019 and 2021 limitation. So in 2019, okay, in 2019 we have a 2019, yes, we have in district, state, national up to 1 crore, 1 crore up to 10 crore, and this is above 10 crore. Okay, in 2021 this is up to 50 lakh, this is 50 lakh to, this is 50 lakh to 2 crore, and this is about 2 crore. So guys, this is very much important. Very much important. C class. Okay, so please remember these jurisdictions. These jurisdictions will be really very much important. Okay, so which type of cases are filed in the state commission? So but obvious, if no year is there, so 2019 you have to remember. Okay, this is one. Okay, the answer will be this one. Okay, next, a stipulation that is essential to the main purpose of the contract and the breach of which give the aggrieved party right to repudiate the contract. It is called what? Warranty, implied warranty, condition, or contingent contract. Essential to the main purpose. This is called a definition term. So from definition portion also, at least 5 to 6 questions will definitely they will ask. So tell me what exactly this statement is. Warranty, implied warranty, condition, or contingent? So guys, main purpose. So main purpose, this is called condition. So condition is also called guarantee. So what is, see, if the word collateral will be given, you have to tick mark on the word warranty. Otherwise, it's a this one. So a stipulation that is essential to the main purpose of contract is called condition. Condition, suppose if I purchase a bottle and I just told the shopkeeper that I have to fill this with the hot water. When I just pour the hot water in my bottle, the bottle become burst. So in that case, I can file the case also. Breach of contract is there. Okay, so these are the things. What is caveat emptor in the meaning? Goods should be free from defect. Ownership of goods passes after sale. Let the buyer be aware. None of the above. So caveat emptor is a legal maxim. Tell me, class. Caveat emptor. Caveat emptor. So this question is from Sales of Good Act. It means let the buyer be aware. It means suppose if buyer is going to any shop, any local shop, and if he purchase, so later he cannot blame the seller, because in a local shop the buyer have to be aware, you know. And the next is caveat venditor. So caveat venditor is also a different thing. Okay, it means let the seller. Let the sailor be aware. Okay, now the doctrine of indoor management is dashed to the doctrine of constructive notice. So guys, both doctrine is important, indoor management and constructive notice. I'll explain you everything. What is constructive notice? Constructive notice, C for constructive. So first of all, this protect the company. C for constructive, C for company. Okay. So in constructive notice, suppose if the outsider have taken from the company, that is MOA and AOA, but outsider have not read. So if he not read, so it is not the fault of company. It is a fault of outsider. So that's why he cannot blame the company that you have not informed. No. In that case, it protects the company. And what is indoor management? Indoor management is simply, it's protect the outsider. Because see, when outsider taken MOA, AOA, okay. So after that, if company change something in MOA and they have not informed to the outsider, in that case, the company will be liable. So that's why this is the exception of constructive notice. Okay. Next. Okay, that's good question. Section based question, class. Tell me. Mortgage, giving movable property as a security. This is called mortgage. Okay, giving movable property as security. Animal is different types of mortgage. Simple mortgage, no delivery of possession. Court will interfere if mortgagee is selling the property. Conditional, mortgage convert into the sale deed. Usufructuary, rent, profit. English mortgage, certain date. Equitable mortgage. So section based questions. Tell me, class. This is D. So D is usufructuary mortgage, okay? E is English mortgage, okay? And F is equitable. And G is anamorous mortgage. So this is the complete type of mortgage. That is important. Cool. Next. Again section base. Mortgage, actionable claim, lease, sale. Mortgage, giving immovable property as a security. Actionable claim for the unsecured debt. Lease, giving immovable properties possession. Sale, selling ownership of the immovable property. That's it. So mortgage, that is in definition 58A. This is mortgage. Sale, this is lease, this is actionable claims. Okay. Okay, now case study. A entered, very important, A entered into the agreement with B for exchanging agricultural land belonging to A for the value 1 lakh itna for a residential house of B value 1 lakh 55. It means A and B have done the contract. A is giving agricultural land. The value is 1,23411 to the B, and B is giving residential house. Value is 1,55212 to A. A transferred land to the B, but B did not have clear title at the residential house. As such, A was not allowed the possession same. Which of the following remedy is available to the A person? Because A have already transferred. This is wrong statement. Because A have already done and B did not have a clear title at the residential house. As such, A was not allowed the possession for the same because, yes. So here, he can sue for both recovery of the property and for the loss suffered by him. C is the right answer. Okay, C is the right answer. B mortgages one-story house to A. B mortgages house to the A. This is the house. Okay. The mortgage is in the form of usufructuary. Usufructuary means rent and profit. During the duration of mortgage, A without permission of B construct 2 more floors and rented them out at the same redemption of property which was statement of apply. Okay. This is very good question. B mortgages one-story house. This is a house. Suppose 3-story. Okay. So we have mortgages this to the A. Okay. The mortgage in the form of usufructuary. During the duration of mortgage, A because who is mortgager? This is mortgager. This is mortgagee. So A without permission of B construct 2 more floors and rented them out. Suppose from this 1 lakh rent is coming. Now he just made this. At the time of redemption of property, which the following will apply. Okay. A is entitled to set out the rent received on the 2 floor. Against this, A is entitled to recover the cost of additional construction. A is entitled to recover the cost of additional construction from B. In the case default, destroy the construction. None of the above. That's cool. First of all, tell me without permission. The mortgagee have already construct. The mortgagee have already construct, guys. That is good question, I think. Guys, none of the above. Because in usufructuary, the person who is the owner, that is B, he have a right over the property now. So how A can construct the 2-story and 3-story building on them? So none of the above is right one. An equitable mortgage has been created in the favor of Bank A in February 1st, 2019. And what is equitable mortgage? No registration is required. An equitable mortgage generally happen in the metropolitan cities. Okay. So an equitable mortgage has been created in the favor of the Bank A on this, which has not been registered. Okay, where a registered mortgage was created in the favor of Bank B on January 28, but it was registered on February 2019. That is good question. This is Bank A, equitable mortgage, 1st February 2019. Bank B, simple mortgage, 28 January 2019, but it is registered in 11 to 2019. So Bank A, because registration mortgage of which took place later, Bank A, no. Give me the answer. This is the right answer. See, for equitable mortgage, no need of registration. So that's why this will implement. Okay, so A will be the right answer. A continuing guarantee apply to what? So continuing guarantee is given in section 129 of the Indian contract. Specific transaction, specific number of transactions, all transaction of specific transaction series, reasonable number of transactions. So continuing guarantee apply to what? Continuing guarantee. Series. C is the right answer. All transaction of specific transaction series. This is the right answer. Okay. Next, number of parties. I'm giving you 1 minute time. Write down the number of parties. Number of parties. Indemnity 2, guarantee 3, bailment 2, pledge 2, agency 2. This is indemnity holder or indemnified. Okay, indemnified, and other party is indemnifier. Okay, 3 parties: principal debtor, guarantor, okay, and creditor. This one, bailer and bailee. Pledge, this is pledger, this is pledgee. Agency, we have a principal agent. So please learn the name because that is important. Indemnity, all the insurance are the example of indemnity. Guarantee, in which guarantor will act on the behalf of principal debtor. It means guarantor will pay on the behalf of principal debtor to the creditor. Bailment, giving delivery of property that is movable from one person to another for the specific purpose, and when the purpose is complete, he can take back the goods. Pledge, giving movable property as a security. Okay, and agency, the agent is doing work under the guidance of this. Okay, that's it. Very important. First of all, read, then I will give you the explanation of this question. This is very good question. See, Mr. Balfour, this is called the case studies question. Mr. Balfour was a civil engineer who served as a director of irrigation for government of Ceylon. Okay. Mrs. Balfour was living with him. It means Balfour and Balfour. That's the husband wife. Okay. Husband and the wife. Okay. They both went to England in 1915 when Mr. Balfour was on leave. In leave, we generally go to the holiday. That's the thing. However, Mrs. Balfour had, it's a rheumatoid arthritis. It's a disease. The weather of Ceylon would be bad for her health. Therefore, her doctor urged her to stay in England. Mr. Balfour verbally agreed to pay £30 every month until she returned to Ceylon, as his boat was about to set sail, because husband have to go for work. So that's why he just promised his wife. However, when their relationship deteriorated over time, Mr. Balfour stopped paying Mrs. Balfour the required amount. In the letter of his wife, Mr. Balfour made the suggestion that they had dissolved their marriage. They later had a legal separation, which meant they were divorced. In 1918, Mrs. Balfour filed a lawsuit against Mr. Balfour for failing to pay the sum he has required in the court. So tell me, class, in this case that whether, tell me yes or no, wife can take money from her husband. What concept is hiding in this question? Tell me, what concept? This is very famous case. It's called case studies question from, see, when you know the concept now, because this question can become in the form of unseen passage. This question can become in the form of case study, just like that. This question can be also come in the form of 2 to 3 line. Okay. So you have to know the concept. Tell me the right answer. So here in this case, guys, if I say, tell you, see, in this case, right, first of all, the concept that is here in this case is legal relationship. What is this? Legal relationship. It means simply between husband and wife, right? Always we just do the promise, we just breach the promise. But in that case, nobody can file the case because that's come under the legal relationship. And what is legal relationship? Where both party have done the contract, and husband-wife marriage is not a contract according to this Hindu law. Okay. So that's why in this case courts say that Mr. Husband has promised, he have not fulfilled the promise. So wife, you cannot file the case. But so in this case, wife can take money. The answer is no. Answer is no. Okay. Now I'm giving you the one more twist in this case. Suppose if the divorce is there, divorce happened between husband and wife. Now the court is ordering for maintenance. If husband is not paying the maintenance now, then you can file the case. Okay, so this is your, this case, Balfour versus Well. This is very important. And the concept that is hiding in this question is legal relationship. Lack of legal relationship in this case. Lack of legal relationships. Okay, that's good. Now, this is again very important case. Now see, Mr. Paul, the Paul Mall gadget carried advertisement from the carbolic smoke ball company that their smoke ball product. The advertisement guaranteed to pay £100 in compensation to anyone who catches the flu after using their ball as directed for 2 weeks, 3 times per day. Additionally, it was stated in the advertisement that they had deposited £1,000 with the Allianz Bank as the insurance. After reading the advertisement, Mrs. Scarlett brought the smoke ball, utilized them according to instruction, but she afterward had the flu. After the defendant rejected the plaintiff claim, the plaintiff filed a lawsuit against, try to get money refunded. So tell me class, first of all, please tell me the concept that is given in this fact. Yes. Concept. Because I have not put the options here. I have not put the options, but still apply your common sense and tell me the answer. So class, here in this case, that is very simple. Let's talk about the journal offer. That is a concept which is in the fact. And what is journal offer? That is for everyone. Okay, that is the journal offer. So here in this case, the lady, that is Mrs. Carlyle, she have just used this according to advertisement, but she just got flu. In that case, she can demand money from the company, because see, it's a general offer. So when lady have taken the medicine, it means she have accepted the offer. Okay, so you have to fulfill if there is a breach of contract. Cool, this is important. Now, very much important case. In every session this question come, in every session. So please remember, it's a very much important. In every session this question come. So first of all, let me write the case name. It's a Mohori Bibi versus Dharmo Dash case. Mohori Bibi versus Dharmo Dash case. Now see, Dharmo Dash Ghosh, the respondent, was a minor who obtained a loan from Brahmodat. So Dharmo Dash is a respondent, was a minor who obtained a loan from Brahmodat, a lender in Calcutta. Okay, so this is Dharmo Dash Ghosh, that's a minor. Just always try to write the diagram so that you can understand and solve the case study. See class, without practicing of this case study, you cannot solve these questions because it takes time. Okay, so he just take money from Brahmodat, that's a lender. Okay, and claiming, the minor is claiming that he is the adult and having executed the mortgage deed in his favor. The fact that respondent was a minor was discovered at the time when mortgage was being examined for the advance payment. As a result, Kedarnath, that's the agent of Brahmodat. So here we have a Kedarnath, that is the agent of this. Agent of Brahmodat cannot execute the deed, but still he executes the mortgage deed from Dharmo Dash Ghosh. Minor filed the lawsuit against Brahmodat through his mother and the legal guardian and urged the court to nullify the mortgage deed because he was minor when he was executed. The mortgage deed was revoked by the trial court. After accepting the respondent appeal, the High Court dismissed the appeal against decision, and then appellant turned the Privy Council. The Privy Council, that's the highest court on that time, to forward the case. When appeal was submitted, Brahmodat has passed. So his successor Mohori Bibi took the place. So he just passed. Mohori Bibi come into picture. Now tell me class two things. First, what about the contract about Dharmodash and Brahmodat? Okay, and the second is whether Brahmodat, that is Mori Bibi, will take refund from the minor or not. Two questions I will ask. Please read the statement and then give me the answer. I'm giving you 1 minute time. So class, here in this case, that is very simple, Dharmodash Ghosh versus this. So in this case, the contract is simply the minor cannot do any contract because the contract with a minor is totally, it's a void ab initio. It cannot convert it into contract, and the refund, no refund will be given. I'm just removing my video so that you can easily see this. No refund will be given to the Damodar because that's a decision which is taken by, okay. So contract is void ab initio and refund, no refund will be given to him. So that's a statement, okay. So, okay. So I hope so. This is clear to all of you because this case is very much important. Just please learn the case name also. Mohari Bibi versus Dharmodash Ghosh case. This is a landmark case where it was held that any agreement which is done by minor is void ab initio. Is that okay? So no need to learn the party's name because in this case the party's name is just to confuse the students, okay? See, Dharmodash Ghosh is there, right? Then Brahmodat is there. Then we have a Kedarnath Mohari Bibi is there, okay? Then Kedarnath is the advocate. Kedarnath is there, okay? The minor mother will be also there. So the character is just to confuse yourself, okay? So that's why focus on the fact. So please learn the case name also because sometimes they just ask the case name. It's a Mohari Bibi versus Dharmodash Ghosh case. Dharmodash Ghosh case, okay? And this is the crux of the case. This is the crux of the case. Is that okay? So guys, do not skip. See, whenever you just solve the questions now, always try to solve first of all the one-liner question, then 2 to 3-liner questions, and then attempt the case studies question because case studies questions takes time, no doubt. So whenever you just start to solve the questions of BRBL, focus on one-liner, then interpretation question, and then attempt the case studies question, and then after unseen passage based question. In the case studies question, if you are thinking that no, this is right, this is I know, don't waste your time because time is very limited, only 2 hours. So if you have a practice of questions, of case study, you can definitely do the questions. Okay. Now, next question we will do. So let's continue the next one. So, dash goods are to be manufactured, produced, acquired by the seller after making the contract of sale. So, this question is from the SOGA Act, that is Sales of Good Act. Okay. So, here we have already done the sale and agreement to sale. So, sale is basically the present sale, and agreement to sale is the what? It's a future sale. So, dash goods are manufactured, produced by the after making the contract. So after, so this is called future goods. So we have a future good, and the specific means that immediately we are transferring the ownership from one person to another. So for 96, A is the right answer. Cool. Next one. Banker lien is what? See, so first of all, what is lien? Lien is basically the holding power. It's a holding that is called lien. So it is basically divided into the two part, that is specific lien and the general lien. Specific lien that's apply on the specific property, and what is general lien? That's applied to the we can say general lien apply to the that is basic. Suppose banker lien. If bank have taken all the security of the customer, so in that case, if customer is not paying the loan, in that case, the bank will hold all the security. So this is called general lien. So banker lien is basically the implied pledge. Pledge, no. Hypothecation? No. Mortgage? No. Because in pledge, we are giving the movable property as a security. Mortgage, we are giving immovable property as a security. In hypothecation, the possession and ownership is with the borrower. So these are the crux. So banker lien is basically the implied one. And what is implied? See, there are two words, that is express and implied. So what is express? Express means that is written and oral. Okay, and what is implied? By the way of act and conduct, we can say the contract is going on. So for 97, C is the right answer. Is that clear? Okay, if you have any doubt, you can please leave in the comment box. I will definitely give a reply. Okay, now garnishing order is issued by what? Police officer, revenue authority, enforcement authority, and the court of law. See, we have a garnishing order. So we have to understand that what exactly the garnishing order is. So garnishing order is basically, suppose if X person have to pay Y 50 lakh rupees, but X right now don't have a money. Now in that case, what will happen? Suppose if Y filed the case in the court, and X is working in a very reputed company where his salary is 5 lakh rupees. Court when get to know that X is working in a very good company, so court will give order to the company of X that you have to pay 10% of the salary of X to the Y till this 50 lakh payment is not done. So this is called garnishing order. A very simple. So garnishing order is always issued by the court of law. So this is very much important. Is that clear, class? This is very much important. Garnishing order. Okay, got it? Now the next one. Next, which among the following is classified as a capital account forex transaction? This is a previous year question. Okay, so your capital account transaction, and we have a current account transaction. So what is the basic difference between capital and the current? C class? If we see the capital account transaction, so in capital account transaction, okay, we can easily just like a loan. or investment. Where money will come, money will go. That is called capital account transaction. And in current account transaction, suppose traveling, okay, traveling we have, and then medical expenses in the foreign country. What is this? Current. So traveling, we just spent, money will not come back. This is called this one. So capital investment, raising foreign currency loan, okay, payment due to connection with foreign trade, short-term banking and credit facility in the ordinary course. So right now we have discussed first and second. So first and second is the right answer. So this is the capital account transaction. So this is the definition term that we have read in the FEMA Act, that is Foreign Exchange Management Act. So this one is the right answer. Okay. Now next. A banking company required dash from dash to undertake banking business as per provision section dash of the Banking Regulation Act. Registration, license, what? Tell me, class. A banking company required dash from dash under section what? This is very important section. I will not say to learn all the section, but section which is important, you have to learn it. So tell me. So guys, if we talk about this question, so this is B. A banking company require the license from Reserve Bank of India under section 22 of the Banking Regulation Act. Okay, because Banking Regulation Act is very much important because so many questions come from this part. Okay, so for 100, B is the right answer. Got it? Next. The Prevention of Corruption Act required that offense be tried by Supreme Court, District Court, Special Judge, High Court Judge. So Prevention of Corruption Act, small act, but so many provisions are there that can become in your exam. So Prevention of Corruption Act required that offense should be tried by what? The special judge. And always remember, these special judge is appointed from the session court. Where? From the session court. That's it. Okay, so this is important. So C is the right answer for this question. That is clear, guys? Okay, session judge, because in session court we have a session judge, assistant session judge, additional session judge. So these judge will appointed as a special judge. So 101, C is the right answer. Cool. Next. What is the latest period by which a trial under the Prevention of Corruption Act has to be concluded in all respect? 4 year, 2 year, 6 year, 3 year. Prevention of Corruption Act and Prevention of Money Laundering Act. In both the act, in the penalty, there is a similarity. Just tell me the similarity. Minimum and the maximum. And in this one, concluded. It means the final they are asking. Final. So tell me the right answer. So guys, concluded. That is 4 year. Okay. So in Prevention of Corruption Act, always remember, punishment 2 year is the minimum. Maximum in four, no, not this is punishment. This is the, when the case can be concluded. So minimum 2 and maximum is 4. And if we talk about the punishment, guys, so 3 year is minimum up to 7 year. This is also in Prevention of Money Laundering Act also. 3 year is minimum, 7 year is the maximum. C class. Very important part. Very important part. Any doubt? Okay. So from each question, you can learn so many more question also. Okay. Now let's do the next one. What is the maximum period of punishment by imprisonment which may be meted out for abatement of offense under the Prevention of Corruption Act. What is abatement? Abatement is to instigate someone. To instigate someone. This is called abatement. Instigate someone. This is 5 year, 8 year, 10 or 7. So the maximum punishment they are asking in the prevention of corruption. So this is your 7 year. That is important. Okay. So for abatement, for final, in every point, we have this much of year of punishment. Okay. So this is important. Next. In metropolitan areas notified as such under subsection 1 of section 8 of CRPC. So what is this Code of Criminal Procedure? Code of Criminal Procedure 1973. So what exactly this is? So CRPC is basically, if I say CRPC, so it's a procedural law. Suppose if any criminal offense is happen now, so in that criminal offense, I can say in that criminal offense, we have a procedural law that advocate and the judge have to follow that procedural law. Suppose in any criminal case like theft, robbery, whatever, FIR will be lodged, then FIR investigation will be done, then charge sheet will be made by the this police, everything will be done. So this is your what? CRPC procedure. So in metropolitan areas that is notified under this, no police officer below which rank is authorized to investigate offense under Prevention of Corruption Act. Inspector of police, deputy inspector, assistant commissioner or commissioner police. So we have a assistant commissioner of police. So in Delhi, we have a special designation authority. In metropolitan cities, we have a different, and in elsewhere means except Delhi and metropolitan cities, we have a different category of police who will investigate the matter. So from this part, this question is very much important. Got my point? Okay. Now, next. As per the Bankers Book Evidence Act, what do you mean by the term judge? Judge of District Court, First Class Magistrate, Judge of Supreme Court, and Judge of High Court. So Bankers Book Evidence Act is basically where the bank, suppose if any matter come in front of the court, so bank do not have to produce the original document, bank have to produce the certified document. So this is your Bankers Book Evidence Act. Okay. Bankers Book Evidence Act. So what is judge? So judge is basically judge of what? High Court. Very important. Many students, just do the wrong one for this question, but please do not do the wrong. D is the right answer for this question. Just, it's a legal fact that you have to know. Okay. Which of the following person are not authorized to issue a certificate under section 2A of the Bankers Book Evidence Act? Because see, bank do not have to produce the original document, bank have to produce the certified one, right? Certified one. So to whom we just require the signature? Manager, principal accountant, person in charge of police station, or none of the above? So the person not authorized to issue certificate is, this is authorized, he is authorized, he is authorized, none of the above. All are authorized to sign in the certified copy. So D is the right answer. Are you getting my point? And I hope so. All questions are easy for you. And today at 11 p.m., do not forget to see a quick revision of BRBL at 11 p.m. Is that okay? So just take a rest after 10 p.m. and at 11 p.m. just see the quick revision session of BRBL. And tomorrow in the morning, that is 5 a.m. Tomorrow in the morning 5 a.m. just see a expected question, expected questions of your BRBL. That is very much important. And tomorrow's session will be live. So tomorrow the session will be live. So most expected questions will be there at 5 a.m. So these two sessions are very, very much important for the BRBL paper. Is that okay? So do not forget to see. Next, a court might order a bank to prepare and produce copies of entries relevant to the matter in issue, accompanied by the certificate that no other entries are to be found in the books, and such order have to be served in how many clear days? Tell me. 3547. Tell me. 3547. 3547. Yes, come on, tell me. 3547. What? Yes, class, this is very important and the previous year question. So we have a 3 clear days. Okay, this is very much important. 3 clear days, that is the working hour. Okay, now, which of the following is not complainant under the Consumer Protection Act 2019? Complainant: any voluntary consumer association, mediator, central authority, legal heir, and the legal representative of a consumer. Tell me, class. Which of the following is not a complainant under the provision of Consumer Protection Act in 2019? So C class, we have a voluntary consumer, this mediator. This can be the complainant, this can be complainant, but mediator is simply a quasi judicial, that's a body. It's a quasi-judicial body. So mediator cannot be the complainant. Okay. So this is the authority who will give justice. So B is the right answer. Okay. Next. Which one of the following is the chairperson of the Central Consumer Protection Council? So council is basically the group of people. Okay. So we have a prime minister, president, finance minister, minister in charge of Department of Consumer Affairs. Tell me, class, the right answer. Tell me the right answer. Yes. Which one of the following is a chairperson of Central Consumer Protection Council? So guys, the chairperson will be simply from the ministry in charge of the Department of Consumer Affairs. So D is the right answer. Cool. Next. How much time is given by adjudicating authority to rectify a defect? Rectify means we can say the amend a defect in the application of financial creditor for initiation of CIRP. What is CIRP? It's a, see the full form, Corporate Insolvency Resolution Process. Corporate Insolvency Resolution Process. So please learn this formula also. Against corporate debtor who have defaulted. So how many days? They just give. Very good question and very important question. Okay, so for this, the right answer is 7 days. Okay, this is the right answer. 7 days is the right answer. Cool. Now, if there are two and more sureties for a loan, what is the status of their liability? Which is not correct. Okay, so guys, we have a contract of guarantee, principal, debtor, creditor, surety 1, surety 2, surety 3. So suppose there are three surety S1, S2, S3. So if there are two and more surety for a loan, what is the status of liability? Not correct. To the creditor, they are liable for the full amount individually. If one of them makes payment, the other is not liable. Their liability among themselves is equal. If one of them makes the payment, then he can recover amount from the other surety on pro rata, which is not made the payments. That is good question. Apply your common sense and give me the answer. Apply your common sense and then give me the answer. Yes, class. So we have to the creditor, they're liable for the full amount individually. This is absolutely yes. If one of them makes the payment, other is not liable. Okay. Their liability among themselves is equal. Okay. If one of them makes payment, he can recover amount from. This is the right statement. But this statement is not right. If one of them makes payment, other is not liable. No, this is not the correct. It may be that he can be liable. Okay, because that's totally depend upon contract to contract. So that's why B will be the wrong. So answer will be B. Cool. Next, which is not the one of the criteria to be fulfilled in the holder in due course. So what is holder in due course? Suppose if X person is working in a company and the company have given the 1 lakh check as a salary. If salary is not credited, X have a right to file the case. So this is called, X is called holder in due course. So which one of the criteria to be fulfilled for a person of the holder in due course? Check should be crossed. It should have been acquired for consideration. It should have been acquired before maturity, and all of the above. That is good question. That is good question. We are talking about the holder in due course, not the criteria of this. So guys, in holder in due course, why should the check should be crossed? Huh? This is for check. And in holder in due course, the one instrument will not come. Any other can be also come. So that's why A will be the right answer for this question. Okay, A will be the right answer. Cool. Next. Which one of the following circumstance indicate a material alteration? Tell me, class. Material alteration. Material alteration. This is very much important because from examination point of view, the material alteration from Negotiable Instrument Act is important. Okay. When the operation of the instrument and the liabilities of the party is altered, when business effect is altered when used for business purpose, when a change impact the instrument in such a way that it starts speaking a different language. So what indicate the material alteration? Tell me, guys. That is good question. Tell me, class. Material alteration. So guys, if you see the material alteration, so we have all of the above is the right answer. D is the right answer. Okay, because all comes under the material alteration. Okay, one question also asked that suppose if Nikita ma'am have given check to the, if Nikita ma'am have given check to the Reshma ma'am and in the check if the name is not written, if I just give to Reshma ma'am by just writing the name, this is not called the material alteration. Okay, so these types of questions will generally come in your exam. Okay, next, Which one of the following is not the example of material alteration necessitating for refusal of the payment of check? That's good question. Ri- Right now, I have discussed this point. Right now, I have discussed this point. When a bearer check is made into the order check, when the date is overwritten, when crossing is obliterated, and all of the above. So obliterated is basically to remove all sign that is something destroying. Okay. So here class, the bearer check. It means the name is not defined. Now, if the name is defined, so this is not come under the material alteration. So that's why A will be the right answer for this question. Got my point? A is the right answer. Next. When a bank is paying a check presented for payment for debit from the saving bank account of the customer, what is the relationship between banker and customer? Tell me, class. What is the relationship between banker and customer? Principal agent, leasee, it's a lesser, debtor creditor, none of the above. Bank is paying a check presented for payment for debit. That's a good question. Bank is paying a check presented for payment for debit from saving bank account. See, whenever this type of questions come now, you have to click first of all the banker relation and then the customer relation. Always. So here we have, see, first word is bank. Suppose if Nikita ma'am is paying a check to the bank. Nikita ma'am is paying a check to the bank. So here in this case, Nikita ma'am is what? Nikita ma'am is creditor because I'm paying the check and bank is the debtor. So that's why C will be the right answer. Okay. Suppose in the same question, if agent is written here and the principal is written here now. So in that case, banker act as a agent and customer act as a principal. But you have to see the name and then you have to click in the right answer. Is that clear? So C is the right answer. Okay, class. Next. Under the Payment and Settlement System Act, which entity is authorized to approve commencement or operation of payment system? SEBI, RBI, Ministry of Finance, or SPI? Tell me, class. So here, class, the right answer will be RBI. This is the right answer. Okay, that's a legal fact only. Okay. Prior approval is required from RBI before system provider causes any change to take place in the system. Exactly. Which would affect the structure or the operation of payment system. However, how many days notice should be given to the system participant after approval by RBI? Tell me. How many notice should be given to the system participant after the approval by RBI? 31 days, 21, 28 days, 20 or 30? Good question. So class, this is but obvious. 30 days is the right answer. Okay, next. While filing appeal before DRAT, if any amount is required to be deposited. See, this is the bank. Bank can file the case to the DRT. Okay, then DRAT. Okay, DRAT. Bank have a 3 year of limitation. DRT to DRT we have a 30 days in which we can appeal, and if anyone want to appeal in this, so we have a 30. So we have a sorry 50%, that is up to 25% we have to pay to the DRT. So while filing appeal before DRT, if any amount is required to be deposited, tell me class. This fees will be but obvious adjusted, but what is the right one? No amount is required to be deposited. Yes, court fee on appeal amount. Yes, 50% of the amount determined by tribunal is required to be deposited at the time of filing the appeal. Yes, after admission of appeal, 50%. No, this is C is the right answer. So 50%, this can be reduced up to the 25%. So C will be the right answer. Okay. Now, can the order of central government in the appointment of presiding officer challenged in any court? Yes, class. So always remember, no. Because see, central government appoint presiding officer, chairman. Presiding officer work in DRT and chairman work in the DRAT. We cannot challenge. We cannot challenge. So B is the right answer. Okay, B is the right answer. We cannot challenge because who will take, uh, who will challenge the appointment that is done by the central government? We cannot appoint. So that's why no is the right answer. Next. A company is under winding up process whether high court permission is required to a bank to proceed against before DRT. Yes, can it require? Because see, this DRT Act is made in 1993. So before 1993, but obvious, the recovery matter come, but that's solved with the help of the court. But when this act come into picture, so we have, you know, the matter can be easily transferred from court to the tribunal. So, High Court permission is required? The answer will be no. Why? Because DRT is a special law having the overriding effect. So this is the right answer. Is that okay? So please remember this one. Okay, next. Very important question. Okay, very important. Just see the question. Solomon, an individual, was a boot and shoe manufacturer. He incorporated a company named Solomon and Company Limited. Okay, and company took over and carried on his personal business. Right. The seven subscribers to the memorandum of association were Solomon himself, wife, four sons, daughter, each taking one share. The company's board of directors was composed Solomon as a managing director and his four sons. Through this board, the personal business of Solomon was transferred to the company for £40,000. In payment thereof, Solomon was allotted 20,050 shares in £1 each and debentures worth £10,000. These debentures certified that the company owned Solomon £10,000 and created a charge on the company assets. One share was given to each remaining member of family. Within a year, company went into liquidation and state of affair broadly like this: £6,000 liabilities, Solomon debentures at £10,000 and ordinary unsecured creditors £7,000. After paying off the debenture holder, nothing would be left for unsecured creditor. The unsecured creditor filed a case against company and contended that through incorporated under this company act, company had never the independent existence at all. This is very good question. Please read this paragraph. Done, class? Now see the question. Okay, see the question. What is the correct proposition regarding the existence of company as an independent entity? We know that if we are talking about the company, so the company have a separate legal existence from the members. So company is a artificial legal person, right? So we have a four option. The unsecured creditor must be paid first since company have no separate existence. Unsecured creditor must not be paid first since company is a separate legal entity. Unsecured creditor must be paid first since company is merely a what? Concepts and its body represent or both A and C. Tell me, class. The right answer. This is a wrong statement. This is the right answer. This is the right answer. Because the This Solomon versus Solomon is the landmark case of the Company Act where it is concluded that the company have a separate legal existence. That's it. Okay. Now, which of the following type of loss cannot be recovered under contract of indemnity? Section 125, that's contract of indemnity, CDS. What is C? C for cost. What is D? D for damage. And what is S? S for sum. So these indemnity holder can demand from the indemnifier. Okay. So damages, cost, payment made in compromise, none of the above. So here cannot be recovered. None of the above. Because all can be recovered. All are the right answer. Okay, so D is the right answer. Next, which of the following types of contract are essentially contract of indemnity? Tell me. Contract to pay compensation, contract to buy immovable property, contract of insurance, or contract for providing certain services. Guys, again I'm telling you, today at 11 p.m. do not forget to see the rapid revision of your BRBL subject. Rapid revision. And tomorrow morning, that is 14th, no, 15th June. Yeah, 14th June morning at 5 a.m. There will be most, and this will be the live one, most expected questions will come. So do not forget to see this session. Okay. So which of the following types of contract is essentially contract of indemnity? Contract to pay compensation, buy immovable property, contract of insurance. This is the right answer. Okay. Except life insurance. That's not covered under the contract of indemnity. That is important. Cool. Next. Number of parties in contract of indemnity and contract of guarantee. Tell me. This is section 124. This is section 126. Tell me, guys. Number of contract in this. Number of parties in a contract of indemnity is 2. Guarantee is 3. Okay. So indemnity, we have indemnity holder and also called indemnified. That is the same thing. And the second party is indemnifier. Indemnifier. Okay. And in contract of guarantee, 3 parties. We have a principal, debtor, creditor, and surety. Okay. So we have a 2 and 3. So B is the right answer. Got my point? Next one. Which of the following party do match the contract of guarantee? Please read all the options and then give me the answer. Person making the promise is surety. Person for whom the promise is made, creditor. The person to whom promise is made, principal, debtor, and all of the above. Tell me, class. Yes, class. The person making promise, the person from whom the promise is made, and the person to whom promise is made is called principal debtor. That is very important question. Do not get confused with the language that is asking here. Okay? Yeah. Tell me the right answer. So here, class, the person making the promise is surety. This is absolutely right. Person form for whom promise is made. This is principal debtor. The person to whom promise is made, that is creditor. Okay, so that's why A is the right answer for this question. Okay, A is the right answer. Done? In the contract of guarantee, the guarantor is not benefited in any manner. That is, no consideration passes to the guarantor. Which of the following is the right one? First, hence a contract of guarantee is not valid. A contract of guarantee, like contract of indemnity, can be without consideration. Benefit obtained by principal debtor is consideration for guarantor. What? Yes, I think my voice was not this one. No? So, guys, in the contract of guarantee, the guarantor will not take any consideration because guarantor is helping principal debtor. So, but obvious he can demand his money and interest from the principal debtor. But the benefit which is obtained by principal debtor is the sufficient consideration for the guarantor. That's it. Okay. Now, series of transaction. What type of guarantee it will be called? Series of transaction. Tell me, class. Series. So series of transaction, that is called the containing guarantee. So this is the right answer. Okay. Next. If guarantor die, what is the position of his liability? Very important question. Very much important. Guarantor die. Very important question. Very important question, guys. See, if I just explain this question, so suppose this is principal debtor, this is creditor, this is surety. Okay. If guarantor die, because see, surety is there who is just giving guarantee on the behalf of principal debtor. Okay. So if guarantor will die now, so what our laws say? Laws say that the outstanding balance in the loan, the estate of guarantor will remain level. Suppose 10 lakh loan amount is there, 10 lakh. Surety have suppose 8 lakh that's belong to his house and 1 lakh that is from the property. So total property of the surety is only 9 lakh. So C, that is a creditor. So he can take only 9 lakh from the surety if surety is dead. This is your law. This is law, class. This is not I'm saying. This is a law saying. Okay. So in this case, the right answer will be B will be the right answer. If guarantor die, the position of his liability for the outstanding balance in the loan, the estate of the guarantor remain liable. That's the law say. Very important part. Okay, cool. Any doubt? You can please ask in the comment box. Okay, next. In the term of contract guaranteed by the guarantor are changed, what is the position of liability of the guarantor? The guarantor remain liable if the liability does not increase. Guarantor is not liable at all. Guarantor continue to be liable if the change is with the concurrence of the guarantor or none of the above. If the term of contract guarantee by guarantor is changed, what is the position of liability of the guarantor? See class, as we know that in contract of guarantee, this is principal, debtor, creditor and the surety. So contract is made between three person, right? Three parties are there, three contract is there. The first contract is between principal, debtor and the creditor. Second contract is between principal, debtor and surety, and the third is between surety and the creditor, as we know. So suppose if the contract guaranteed by guarantor are changed. So in this case, the guarantor will be continue to be liable if the change is with the concurrence of the guarantor. C will be the right answer. Got it? Next. If bank does not sue borrower in a court even after default in the payment, tell me what will happen? What will happen, class? Bank cannot demand the repayment of loan from guarantor. Bank can. Okay. It means bank is not suing the principal debtor. Okay. So what will happen? Bank can demand the repayment of loan from the guarantor alone. The bank can demand the repayment of loan only simultaneously. Bank cannot demand the repayment. Bank can demand this. So here, bank can demand from the guarantor alone because still the creditor is not filing the case or whatever. Surety will be always liable. Surety will be always liable. So this is the right answer. Okay, that's it. Cool. Next. Where the bank releases one of the joint guarantor, what is the position of liability of other guarantor or the borrower? Tell me, class. Other guarantor continue to be liable. Other guarantors as well as borrower do not remain liable. The guarantor as well as the borrower continue to be liable or what? 130. That is good question. So guys, all questions that I have asked in my session, that is very much important, that will definitely come in your exam. So it's the joint guarantor. We are talking about the joint sureties. So here the other guarantor will obviously liable. Okay. So guys, I hope so you people enjoy the session. Okay. And let me do a quick revision that whether you people have seen or not. First, I hope so you people have seen the BRBL guide. Just ask yourself, because in BRBL guide I have covered the Macmillan book summary plus question. I hope so you people have seen. Second, in my session I have done A plus B mini marathon. I hope so you people have done. Then C plus D mini marathon. I hope so you people have done. Then important appeal, penalty, sections, limitation, legal maxims, etc. I hope so you people have seen. So these are the important videos that we have already done in my session. Okay. If you have not seen anything, we have a separate playlist. You can please go to the channel, open JAIIB CAIIB English Medium channel of Officer Adda. Click on the playlist. You can see my session. Okay. Then we have done the mock paper. Please do not ignore this mock paper also. This is very much important. Whatever questions I have asked, all questions are important. Done. And then we have done the Maha Marathon. That is important. Okay. Then 6, 7. 7th, we have done this final revision. This is important. Okay. So these are the question session. The more questions you will solve, the more confidence will come in your mind. Okay. Then, yeah. Then today at 11 p.m. rapid revision. Do not forget to see the rapid revision. And the 10th morning 5 a.m. we will do the most expected question. So two sessions are remaining. Rapid revision 11 a.m. that will go on, and most expected question, that is 5 a.m. morning, that is of 14th June. So please do not forget to see the session. So right now wait for 11 p.m. do rapid revision, and 5 a.m. in the morning live session will be there. I will take the live session. Do not skip. Okay. And then A plus C and B plus D quick revision session is also there. You can see the session in the playlist. So I think these sessions, if you people have done, I'm damn sure you will crack this paper with 80 plus marks. I'm damn sure. So these all sessions are very much important. Okay, so just do everything and wait for 11 p.m. and tomorrow 5 a.m. Okay, so this is my Telegram. You can please join this Telegram by scan this Telegram. Okay, and you can ask doubt anytime, anywhere. Okay, and please do that question in which you have a full confidence. Okay, so that will maintain the accuracy, and just be positive and hope for the best one. Okay, so guys, in BRBL subject, first of all, try to solve the easy question and then 2 to 3 line questions. And then after, just do the case studies question and the unseen passage based question. So that's a way to just boost up your confidence. Otherwise, suppose if you just do the this type of questions now, unseen passage, you cannot achieve the thing. So that's why please focus on this one. Thank you so much, guys.